Francis, I am mentioning electricity matter. Well, 20 matters are in the list, my lord. It cannot be reached out. Well, electricity matter may be taken up once in a week or twice, my lord. It will be taken.
You are actually right, Mr. Haldar, because I was also thinking the electricity matters and small matters.
And now it is
Of the matters are either tender or company or major, taking long hearing. And I thought that I would be disposing of these upgraded matters first, but it's not working because most of the upgraded matters are full-fledged hearing matters. And I cannot reach these small matters.
Well, electricity once in a week, my lord, it will be disposed of.
Definitely.
It will be disposed of.
Electricity matters, can you give your
yes,
your particular
yes.
list of matters?
Yes.
If there are others who are with small electricity matters, please give that list also.
Mal.
By recess, please give that so that we can put them at the top tomorrow. Kalke upgraded top tumi electricity matter gulo diye dao.
My lord, under compelling some exceptional circumstances have come before your lordship. My lord, petitioner being a successful bidder, already invested 1 crore 6 lakhs before the SEBI, and lordship already disposed of one application, actual application of this present petitioner, which is here. My lord, as today's list, item number 154. SEBI is going to conduct the auction today itself. It is serious jeopardy, my lord. 1 crore 6 lakhs is the NRI.
How are you affected by the auction?
They have already expelled me. They are going to afresh. Lordship, kindly have a look of your lordship's order.
I cannot take up the. Actually, I don't have time to take up the. Sorry.
Lordship, kindly have a look of the
order. My offense is that I have been elected as Pradhan by the support of independent candidates.
Yes.
I have been asked to deposit my caste certificate by tomorrow. 808 caste certificates was issued with the persons having my lord's surname Bogal, BAGAL. Department already directed, make an inquiry whether this caste is properly entitled to have this or not. So that proceeding has not yet been ended.
No, Mr.
But since I have been elected as Pradhan, my lord, now if I deposit tomorrow, I would not be handed over charge of the Pradhanship.
Wait for some time. No.
My election will go, my lord.
Yes, what is?
Lord, I have one extreme urgent motion.
Yes.
Lord, motion, my lord, I am a vehicle in respect. I am a owner in respect of a vehicle. Yes. My lord, that met an accident. My lord, I claimed insurance. My lord, a criminal case was started, charge sheet submitted, wherein it is
your
clear.
claim is for that money for insurance claim?
Yes, my lord.
No, not now. Call on the list.
For judgment, item number 1.
Accordingly, WPA 29085 of 2023 is disposed of by directing the respondent number 1 to ensure that the petitioner is brought under the care of the respondent number 9, the Child Welfare Committee, Purbo Mednipur, to SSKM Hospital in Kolkata within 24 hours from now under competent medical supervision. In the meantime, a medical board has contemplated in section 32D of the MTP Act 1971, consisting of a gynecologist, the usual composition, shall be formed. The said medical board shall examine the child immediately after her being brought to the SSKM hospital for ascertaining the pros and cons of medical termination of a pregnancy. In the event it is found that the scale tilts in favor of the termination of such pregnancy and the survivor petitioner's health will not be jeopardized upon a medical termination of pregnancy procedure being conducted on her, and that the petitioner is agreeable to such termination because he has intelligence. The SSKM hospital shall immediately arrange for experts in the field to carry out such medical termination procedure on the petitioner. It is expected that the entire exercise shall be concluded within 48 hours from the arrival of the petitioner to the SSKM. 24 hours she has to be brought, medical team has to be formed. After 48 hours from that, within 48 hours, it has to be done. In the event the process culminates in the birth, this is borrowing from the Supreme Court. In the event the process culminates in the birth of a live fetus, the SSKM hospital shall give all necessary medical support to the said child and, subject to the extant law in the field, place the child for adoption before an authorized agency in due process of law. After the entire procedure is over and the petitioner recovers fully, she will be discharged from this SKM, and the CWC Purbo Medinipur shall take steps under the appropriate statute to place the petitioner in juvenile care under the relevant statutes in the event the petitioner remains deserted by her parents and family. During the entire process, the CWC in Purbo Medinipur shall also take proactive steps to protect and take care of the minor sister of the petitioner as contemplated under the relevant statutes. If she is also found to be deserted by her parents and family, otherwise she will next come to this court.
Yes,
and family, and or found to be a child in need of care and protection, if possible, housing her with the petitioner since they are apparently their own close family, their only close family now. Party shall act on the server copy. No order is to cause.
Deeply obliged.
Thank you.
No words.
Grateful.
Only
For
one.
being there when the order is passed. Yes. No, Mr.
small-
Thought the difficulty is there are
Some
certain
correct.
because I had a problem with Microsoft Word yesterday across the board. It is online, so I had to do it through Google Documents, and this is a PDF file, but it transpires that you show it to them.
Yes.
Daud. It transpires that some of the paragraph numbers are coming like this.
Oh.
So the difficulties we have to
I-
convert in Word,
I-
and by recess I'll be signing that.
I understand. After it is signed, only a small request so that it is server after signature. as quickly.
Immediately.
Alright,
They are waiting for the server after the signature.
Deeply obliged.
Yes, thank you.
Deeply obliged.
ঠিক করে পল্লবকে বলে দিও থ্যাংক ইউ ভেরি মাচ ইয়েস দুটা কল করে তুমি ওটা করো
For judgment, item 2.
Madam, I am for the petitioner.
ইয়েস
I'm for the malady.
accordingly WPA 18398 of 2023 is partially allowed, thereby setting aside the memo dated April 20, 2023 issued by the additional district magistrate Malda to the district registrar. There shall be no bar to the petitioner's development agreement being registered in accordance with the provisions of the Registration Act and all other governing rules and regulations pertaining to registration by the district registrar Malda in due course of law. Full stop. The petitioner will be at liberty to approach the NGT seeking to add itself as a party, primarily to point out the question of jurisdiction of the NGT to take up OA number such and such. If so approached, the NGT shall act on a server copy of this order coupled with the communication of the learned advocate for the petitioner and give an opportunity to the petitioner to produce documents and of hearing. And upon giving such opportunity of hearing to the petitioner and the applicant therein, both of you decide the question of maintainability of the said OA in the light of the above observations at the earliest. No order is to cause urgency requirements.
Grateful,
I have not held from here that the NGT does not have jurisdiction
Lordship.
because I've observed in my order the NGT should be given an opportunity to consider this. We should not do it from here.
Lordship. May I point out one thing for your Lordship's kind consideration? But
Yes.
there are 7 other matters on similar footing appearing in your Lordship's list. But may I give
I can only advise you to keep a copy of this order and mention those matters.
Malot, only one thing, Malot. The NGT, Malot, assuming jurisdiction passes order one after another, then Malot, I'm only praying, Malot, let this question be first decide. Jurisdiction question.
What have I directed?
Malot had said so, but in the next occasion, he should concentrate on this issue first.
Let him not. Yes.
And may I come back on Monday and then mention these matters?
These are not urgent matters. Don't.
Top item, item 3.
See,
I am for the respondent number 2.
Yes.
Lordship, I am on behalf of the petitioner, Lordship.
No, Lordship, my senior is appearing to virtually, Lordship.
yes.
I
right.
filed
But,
GST affidavit
oh,
of
Mr.
service.
Actually, I am suffering from typhoid. That's why, Lordship, I am under compulsion.
I took my head. I thought she was praying for time. That's why. Yes.
No.
Move the matter. Yes.
This on the last occasion, his lordship has directed the district judge Barasat to submit a report.
That
My lord,
matter.
Yes, my lord. My lord, may I file the report?
The zonal judge had a talk with you.
I had.
Lordship, already as per your direction, Lordship, I have served the copy of the order upon the learned district judge and upon learned additional chief judicial magistrate also.
ACJM was also directed.
Yes, both the reports
Both are
are
there,
lordship.
yes.
Now, my lord, one thing I just pointed out to his lordship, my lord, that in the order of his lordship on 23rd of September, so 23rd of my lord, July, my lord, it should have been pointed out by the petitioner
Right.
that the case number is, my lord, Belghoria PS case number 190, as has been mentioned everywhere in this petition. But inadvertently, my lord, in that order, my lord, which has been communicated to before the district judge and others, my lord, it has been mentioned as 191.
Why was the district judge not represented on the last occasion?
No, my lord, we do not have the writ petitions and all, my lord. That's why, my lord. But for that, my lord, I am tendering unconditional apology before his lordship.
Should have been just represented
Yes.
and said this to the court.
Lordship,
That would suffice.
but my lord, since my lord, I am tendering
Because
on
our
behalf of
district judge, we have a duty, Mr. Boshumulli, to
Lordship,
protect
lordship.
our district judges and magistrates.
Absolutely.
They are our officers.
Absolutely,
Remember
my
that.
lord. Absolutely,
But
my
if
lord.
they choose not to come, if they are
No,
my
my lord,
brothers
my
and
lord.
sisters in
Yes,
our
yes.
profession,
Yes, my lord.
this is just a matter of hierarchy. But if they don't, if they
My lord.
choose not to comply with orders, they have to suffer.
My lord, my lord. I am always, my lord.
I am also
That's
not
why-
above the law. You are
No,
also
no,
not above
no,
the
no.
law.
That's
Neither
why,
are the
my lord,
district judges or the district
That's why, my lord, yesterday evening when landed government
judges.
told
Represent
me,
through somebody. Why is
exactly,
this
my lord.
practice not adopted? Represent through whoever. Senior most advocate of the High Court and tell the court this is the problem.
But my lord, yesterday evening, my lord, this has GP has told me to appear, my
But
lord.
I must apologize, my lord. We had given it, my lord, to a person, my lord, who could not appear on that. My lord, it is our fault, my lord. That's why, my lord, I'm very sorry, my lord.
Represent them through somebody so that we can
That's
pass
why,
order. If it's a
I
wrong.
know, my lord, it was given out for appearance, my lord.
Anyway, what does the report say?
No, my lord. All the records are available, my lord. Both these records are available, my lord. And not only that, my lord, in 2021, my lord, the petitioner has received charge sheet in one matter, that is, my lord, 190, Belghoria PS case number 190, wherein, my lord, in 2021, he received the charge sheet, and my lord, the next date is fixed on 17/11/2023.
Yes.
And so far, the other cases
do these reports contain information regarding the entire interview?
Lordship.
So, is there anything discrete in the reports which should not be disclosed to them, according to you? If these are public records,
no, my lord.
Then I'll request you to circulate copies on them, and their grievance will be redressed. Then they can take steps, whatever.
I think, my lord, it would not be appropriate, my lord, to give it to the my lord, party, my lord, petitioner.
Why do you say that?
Because, my lord, since, my lord, it is a report of both the SCGM and district judge, and it has been communicated before.
I can direct them. I can direct you to communicate whatever is the content here.
But lordship may record it in the order so that, my lord, that can suffice, my lord. I think instead of giving it to them, my lord.
Lordship, after receiving the copy under section 207 of CRPC,
half an hour just to dictate the contents of the.
I am
just the numbers. So the reports. Very well. The report I'll not direct you, but
lordship,
the contents of the report you can very well do.
I shall, my lord.
So copy paste from apart from the respected sir and above. Other than that, everything copy paste and give a copy.
Lordship, I shall.
Yes. What do you say, Mr. Mukherjee?
Lordship, with your permission, Lordship, I want to say one thing, that Lordship, in my representation, that is page number 12, Annexure P1, I had mentioned the case number, okay, that is the Belghoria Police Station case number 190 dated 27/2/2017, and Belghoria Police Station case number 404 dated 4/5/2017. Lordship, the problem is that after receiving the copy, Lordship, under section 207 of the Code of the Criminal Procedure, after receiving the copy of the charge sheet and as well as the copy of 161, the record cannot be traced out.
That is not correct, my lord. That is not at all correct. Well, I have the entire the record of both these cases, my lord. Wherein, my lord, constant.
Lordship, the problem is that after receiving the copy, the record cannot be traced out, and due to that very reason, I preferred one petition to trace out the record, Lordship. I preferred one petition.
But if it is not traced out,
Mr. Mukherjee and Mr. Bosumalik, if you are done, I'll pass my order now. Learned Council, the learned district judge of you are district judge of
Barashat, Lordship.
Barashat and
Barakpur.
Learned district judge Barashat, district North 24 Parganas and ACJM Barakpur file their reports as per previous direction, in sealed envelopes which are opened in court today, through council. First up, it transpires from the reports that details of the cases pending in connection with the petitioner and allied affairs, which was the grievance of the petitioner, have been supplied in the said reports. First up, accordingly, if the contents of the report are circulated among the petitioner's advocates, the grievance of the petitioner in the writ petition would be redressed. First up, needless to say, the petitioner would always be at liberty to take appropriate steps in connection with the said pending criminal proceedings, if any, against the petitioner, before the appropriate forum. First up, hence, WPA 13212 of 2023 is disposed of by keeping the reports filed today on record and Mr. Bosumalik, circulate the reports, by directing the you are for the state, Mr. Bosumalik.
No, I am for the respondent number. State is Mr. I am for the respondent number 2 and 4, led by learned government.
Learned by directing respondent numbers 2 and 4 to circulate the reports filed by them in court today to the learned advocate for the petitioner during the course of the day. Full stop.
Lordship, I am deeply obliged, Lordship.
Observed above, comma, it will be open to the...
I hand over.
আচ্ছা তার পরের লাইনটা তাহলে দাও pursuant to the above direction comma such circulation is made here and now full stop next para needless to say comma the petitioner will be at liberty to take appropriate steps before the appropriate forum in connection with the criminal proceedings comma if any comma pending against the petition. No address to cause.
Lordship, with your permission, may I say one thing, Lordship?
You may say two things also.
Lordship, the vital thing is that what is the next date and in which court the record has been transferred.
It is for you to trace out now.
On the
if you get the numbers, detailed numbers, then
on the last order, Milord, his lordship has mentioned that if record not produced, then Milord, service book
yes.
and all, Milord.
Yes.
Can expunge that line, Milord?
No. I have not put anything in the service.
No, yes.
After line add. Since it is pleaded by learned counsel for the respondent numbers 2 and 4 that the non-filing of the reports previously were not deliberate, but due to mere miscommunication, comma, it may be recorded that such and such was. If whatever is say, Mr. Bushmalik, that will go in the service book now. If I say let it not be put in the service book, that has to be put in the service book.
No need. No.
Let us not be on that.
Since Milord, lordship has disposed of this matter,
yes,
lordship, grateful, lordship.
I am deeply obliged, Lordship.
Item 4.
Yes.
My lord, I beg to appear on behalf of the state respondent, my lord.
I beg to appear, Milord, on behalf of the petitioner.
Yes,
Before Milord, I move the application. I just indicate one thing. Milord, I'm sure my learned friend is appearing for the creditor. Milord, a service was attempted by hand, Milord, yesterday. Milord, upon the learned advocate and also upon Milord, the secured creditor, Milord, the bank, Milord, the financial institution. They refused, Milord.
Lordship, I beg to appear for the secured creditor. Lordship, service admittedly was attempted on me, but Lordship, till then I was not assigned the matter. If Lordship may kindly consider that. And as far as I have instructions, Lordship, even till 10:30 today, a copy of the writ has not been served, Lordship. No attempt has been made on the...
What is the urgency in the matter?
Milord, the urgency lies in the fact that, Milord, a section 14 order has been passed. Milord, we mention the matter so that, Milord, the possession of my asset is not, Milord, taken, Milord, on the strength of that order. Milord, after the matter was mentioned, they came to learn that, Milord, the matter has been mentioned. Milord, they came and, Milord, barged up into my property, took, Milord, forcible possession at around, Milord, 2 p.m. yesterday.
Lordship.
And, Milord, I can show, Milord, here and now, Milord, from the order that the order is, Milord, absolutely without jurisdiction in complete breach of, Milord, the statute.
Lordship, from two things, Lordship, if I may indicate.
You're ready, yes.
Lordship, mentioning notice was not served upon us. We were not aware in any way.
Technically, you refused.
No, Lordship, we have not been served. Let them show that we have been served with the mentioning
I'll dispense with
notice.
service under Rule 26.
I have prayed for
this attitude of the security creator is grossly deprecated.
Lordship,
I'll direct you to return the rest of the possession. After that, we'll hear.
Lordship, we have not been served with
No, this is not done. They are before a court of law. They have mentioned the matter yesterday. They sought to serve you. You are not empowered till then by the bank
Yes,
or
Lordship.
secured creditor, and you take possession at 2 p.m. You will restore it. You will repay them. You will pay them cost, and then, if necessary, I'll direct you to take possession.
Lordship, then Lordship may kindly pass it over.
Message has to go, ma'am. No.
Lordship,
Let me hear them on urgency. I'm dispensing with Rule 26 under Rule 26 service on.
That's my first prayer also. Kindly, Milord, turn to page 130, Milord, of the writ petition.
Yes.
Milord, this is, Milord, the order passed, Milord, under section 14. I, Milord, do not trouble your lordship, Milord, with Milord, the entirety of the order. Kindly, Milord, turn to page 133.
No, Mr. Banerjee, be under no misconception. If you don't make out a strong prima facie case, you don't get an order.
No, Milord,
this will happen only if you make out a strong prima facie case.
Milord, I can show that from one sentence only. It's so, Milord, apparent.
Yes.
Kindly, Milord, turn to page 133.
33, yes. This is a section 14 order.
Section 14 order by Milord, the Chief
yes.
Judicial Magistrate. Milord, the sealed bailiff has been appointed as the commissioner to take possession, who has come and taken possession. Now, Milord, I show, Milord, the provision of law. Milord, will kindly just take note of, Milord, the first sentence in the ordering portion at page 133. Then kindly take, Milord, the provision of law.
Yes.
Milord has seen, Milord, the sentence.
Yes.
Now, Milord, will kindly, Milord, take section 14.
Yes.
My lord, there is a proviso, my lord, section 1, subsection A, my lord, is incorporated later by of an amendment. Kindly see, my lord, the district magistrate or the chief metropolitan magistrate may authorize any officer subordinate to him to take possession.
No, this is section 14.
Section 14, subsection 1, capital A. New incorporation.
Yes, I'm sorry. Yes.
I'm sorry. My lord, it says district magistrate or the chief metropolitan magistrate may authorize any officer subordinate to him, my lord, to take possession. And my lord, there is also a provision that, my lord, this order should be passed, my lord, within 30 days. My lord, second proviso, my lord, to subsection 1.
Yes.
My lord, there are, my lord, 2 very recent Supreme Court decisions which say that, my lord, here time is the essence. My lord, the order has been admittedly passed, my lord, after expiry of 30 days. My lord, I am not, my lord, heavily relying on that, but I will show, my lord, those decisions and, my lord, what, my lord, Honorable Supreme Court has held. And, my lord, in the same judgment, the Honorable Supreme Court has also held, my lord, an officer means an officer, not, my lord, a clerk or a peon. My lord, I can show, my lord, from the service rules of, my lord, the subordinate staffs of the subordinate courts, my lord, who are seal belief is. Please.
Yes.
My lord, this is West Bengal District Court Constitution of Service, Recruitment, Appointment, Probation, and Discipline of Employees Rules 2015. Kindly, my lord, turn to Rule 10.
Which bank is this?
My lord, this is Aditya Birla Finance.
All right. Yes. Please continue.
My lord, Rule 10.
Rule 10. Yes.
My lord, method of recruitment of process server, bailiff, summon bailiff, seal bailiff.
Yes.
The method of recruitment of process server in the district or city court or city sessions court or presidency small cause court or any other court in equivalent rank shall be such as specified in Schedule 1, and the recruitment shall be conducted by the district recruitment committee, etc. Then, my lord, kindly take Rule 15. And kindly see, my lord, this comes, my lord, this Rule 10 comes under, my lord, Chapter 1. Chapter 1 is at, my lord, internal page 5 of the rules. I'm sorry, this is not Chapter 1. Chapter 3, my lord, at internal page 6. My lord, I apologize, my lord, for this. My lord, Chapter 3, method of recruitment. My lord, you kindly see, in Part 1, firstly comes, my lord, ministerial supervisory cadre. Then, my lord, in Part 2 comes stenographers. Then, my lord, on Part 3, process establishment, under which, my lord, seal bailiff comes. Then, my lord, kindly take Rule 15. Process establishment. Has, my lord, kindly...
Yes.
Rule 15. Method of recruitment of process server or bailiff. The method of recruitment of process server in the Court of Civil Judge Senior Division or the Chief Judicial Magistrate or the Chief Metropolitan Magistrate or the Additional Chief Judicial Magistrate, etc. or any other court in equivalent rank shall be such as specified in Schedule E, and the recruitment shall be conducted by the District Recruitment Committee. My lord, I will immediately take your lordship, my lord, to the schedule, my lord, which is even more important. Kindly, my lord, before going to the schedule, take Rule 20 once. My lord, I'll just show the provisions that deal with, my lord, seal bailiffs. Rule 20, my lord, deals with method of recruitment of process server or bailiff. My lord, it refers to Schedule E.
Right.
Then, my lord, kindly turn to Schedule, my lord, A and Schedule E. Kindly take Schedule A first. My lord, this is internal page 23.
Yes.
My lord, again, serial number 1, my lord, there are 4 columns. Kindly take, my lord, the first column, my lord, serial number, second column, name of the court, third column, my lord, towards the end, towards the bottom of, my lord, again, serial number 1, my lord, will kindly find process server, bailiff, summon bailiff, seal bailiff, etc.
Group C.
Group C.
Right.
Then, my lord, kindly turn to Schedule E. My lord, at page 28. Kindly see, my lord, what are the eligibility criteria to be appointed as a process server or seal bailiff? Class 8 pass. And he comes and takes position as a subordinate officer.
What is the difficulty?
My lord, show, my lord, the decision. My lord, this is reported at 2022, volume 10 Supreme Court cases, page 286. Only 2 paragraphs, my lord. Kindly take paragraph 38 first.
Page 286. NKGS.
My lord, a question arose, my lord, whether an
38.
my lord.
Yes, question arose.
My lord, the question that was, my lord, posed to the Honorable Court in this matter, my lord, was whether an learned advocate of, my lord, the court, my lord, can be appointed as, my lord, a subordinate officer.
Yes.
My lord, the question really was that, my lord, a learned advocate is not administrative control, my lord, of, my lord, the Honorable Court. So, my lord, there is no administrative subordination. But, my lord, there is moral subordination. My lord, the Honorable Court held an advocate can be appointed. And while holding so, kindly see, my lord, what the Honorable Court has, my lord, said further.
That's a different question, Mr. Banerjee.
Kindly see, my lord, while
an advocate comes within the purview of
while
this
deciding that question, my lord, what the Honorable Court has held, my lord, in paragraph 38.
38, yes.
My lord, it says, furthermore, as was the situation obtaining before insertion of subsection 1 capital A, wherein the Chief Metropolitan Magistrate or the District Magistrate could avail the services of an advocate of any officer subordinate to him for discharging the ministerial work of taking possession of the secured assets and documents, nothing prevents him from continuing to follow the same regime even after insertion. At the same time, while entrusting the act of taking possession of the secured asset consequent to order passed under section 14(1) to any officer subordinate to him, the CM, the Chief Metropolitan Magistrate, the District Manager ought to exercise prudence in appointing such person who will be capable of executing the orders merely because he has power to appoint any officer subordinate to him. It do not permit him to appoint a peon or a clerk.
Mr. Banerjee, peon or clerk is not on hierarchy. It's on the specialization of the service. Peon or clerk does office service. Process server does this specifically, what he has done or she has done.
He, my lord, only serves notice.
This is not, because we would be extremely feudal if you say that there's a classification, process server, peon and clerk, who are different from advocates. Judges, advocates, peons, clerks, process servers, all are citizens of India, sir.
My lord, in the same
so if one is class 8 pass and one gets the opportunity in life to be a law graduate like I am, only a law graduate, nothing else. Nothing else. By stroke of fate, I've become a judge. Does not mean, Mr. Banerjee, that a process server is worse equipped to handle situations in life than me. This is only on the specialization of the work.
Absolutely. My lord, the
advocate, I don't know, it was because it is Supreme Court, it's binding on me. The Supreme Court says an advocate is equally equipped like a process server to go and give possession. So if that is the view of the Supreme Court, it binds me. The advocate also has that specialty.
Apex Court has held that, my lord, any clerk or peon won't do. My lord, why, my lord?
No, any clerk or peon definitely won't do. No, now, not any. It would not permit him to appoint a peon or clerk
who is incapable of handling the situation.
A process server is specifically equipped to handle these situations, Mr. Banerjee.
My lord, may I, my lord?
Process server,
may I, my lord, humbly? May I, my lord,
humbly? For the process server. Wait a minute. Let him.
May I, my lord, humbly join issue there.
Yes.
My lord, a process server, my lord, is not, my lord, trained, my lord, to take possession with the help of police assistance, my lord, in a situation like this where, my lord, a section 14 order is passed.
What is the difference?
My
lord, process server, if he's equipped to take police officers and give possession regarding eviction suits, why can't he?
My lord, here, my lord, firstly, the immovable property was mortgaged. My lord, what has been taken possession of includes, my lord, the movable assets as well. My lord, no.
See, the discretion has to be exercised. What are the assets and all this?
Absolutely.
All right.
Absolutely. And, my lord, yes, nothing has been done. At least, my lord, to my knowledge, my lord, no inventory has also been prepared. My lord, this has happened only because of, my lord, an incompetent person has barged into my property. And, my lord, I have more fundamental.
One question to you before we proceed further on this.
Yes.
Now, are you arguing only on the taking of possession by them in the meantime, or this is the main matter? This is the main challenge also.
No, my lord, there is more fundamental a challenge to this. My lord, I have
am I hearing you on interim orders?
Yes.
Very well.
Yes.
This is one aspect of the matter. What is that?
But, my lord, it is absolutely up to your lordship, my lord, whether my lord will, my lord, dispose of the matter today or not.
What is the main challenge?
The section 14 order. My lord, I want to challenge the section 14 order in, my lord, a sufficiency action, because I am, my lord, lawfully entitled to do that. In fact, my lord, I have taken out a section 17 application at the, my lord, symbolic possession stage. My lord, the essay is pending. Now, my lord, section 14 has, my lord, Honorable Supreme Court has again held, there is an extension of section 13 subsection 4. So, my lord, I get, my lord, 45 days time, my lord, to challenge, my lord, that order. My lord, that is the time the statute gives me. Here, my lord, the order was passed, the order was communicated, and my lord, within 3-4 days, my lord, the possession has been taken. My lord, I don't get the my lord, time, my lord, provided to me by the statute. My lord, I am amenable to the proposal that my lord, I will go to DRT and challenge
When did you
this.
file the 17?
My lord, 17 was filed at the my lord, symbolic possession stage.
Date?
My lord, the date of filing
at least month.
Much before section 14 order.
Much before?
My lord, I just
so what are you doing in the meantime? Why didn't you obtain an interim order?
Because section 14 order was not there, and my lord, symbolic
section 14 need not be there.
No, symbolic.
You file a section 17, you wait till the section 14
no,
and come to court. See, section 14 has been, section 14 is not the impetus which is there. I mean, section 17, the moment you file a section 17, it's your incumbent duty to take an interim order.
I filed, my lord, the section 17 application at the symbolic possession stage.
There,
my lord, no interim order is ever passed. My lord, symbolic possession stage, because I am in possession only.
So, Banerjee, you cannot pray for a restraint order there, not taking possession if you make out a prima facie case. Definitely there is scope. Section 17 is the forum.
My lord, that would have been an injunction key at not subject to correction by
Why
your
not
lordship.
Injunction? So section 17, is there any bar from passing a restraint order? I don't think so.
Going by my little experience in DRT matters, usually
no, that is not a.
Are not
section 14, that cannot be made a rule of law, Mr. Banerjee, that only after the section 14 is filed, then we'll take out an application.
No, I have taken out an application.
They have been prompt. Unfortunate for you.
But I get under the statute 45 days time from an order passed under section 14.
The moment the section 14 order is passed.
Yes.
When was the section 14 filed?
The section 14 application was filed on 29th of May 2023. My lord will kindly turn to page.
And your 17 was pending then, obviously.
Yes. And
so why couldn't you obtain an order?
And that was not disclosed even before the learned Chief Judicial Magistrate, which is one of the 9 points under the section 14. That was also not disclosed.
This is not a good law. What is your primary challenge in that section 17?
Well, symbolic possession. Notice, the possession notice, I show to your lordship, which is under challenge in section 17.
Does it become infructuous according to you if they take possession under 14? Does not.
I do not.
You can pray for status quo order even now before the section 17 forum.
I can also pray for restoration of possession. under section 17.
Right.
I can also pray for that.
Exactly.
But I am on a more fundamental question, subject to what falls from your lordship.
Peon clerk distinction, I am not accepting.
Not swallowing, this is one of the points that would convince your lordship.
Obviously, Mr. Banerjee.
And kindly turn to page 69 once. This is the subject matter of challenge as of now, in my section 17 application. Only a possession notice was affixed saying that they have taken symbolic possession. Immediately, I assailed that. But to my subject to my limitation of understanding, time was not ripe to pray for an interim protection then.
68, yes.
69. Well, this was symbolic possession.
Obviously, yes.
Yes. I immediately challenged this. This is first step under section 13.4. I didn't wait, I challenged this.
What else remains before this and section 14? There is no further
that is not physical possession. I am ousted by application of
obviously you will be ousted. And section 14 is for that.
Provided the order.
Wait sweetly for the section 14 to be filed. And now you come up and say, never knew.
I never knew that a section 14 has been taken out.
You took the risk, Mr. Banerjee. You took the risk.
I never knew.
The moment this rule 8 is issued, I mean, you should take care of that. You file a section 17, keep it pending.
No, that I'm appearing there. They are supposed to put in their opposition, which according to my knowledge, they have not yet. And I didn't know that a section 14 has been filed. And there is one more point.
No, notice of section 14 is required to be given to you.
No, that's why. So you cannot take that administrative order. I'm not urging that
section 14 is not for this new execution proceeding under order 21.
It's administrative order.
It's not that. It's not order 21.
True.
Because there is no 9700.
True. I will show one more thing, which may be even more palpable.
More impressive.
Yes, even more palpable. I'll show who has filed the application.
I'll put in 1 or 2 remarks against Aditya Birla for taking this modus operandi, but cannot restore possession to you on these grounds unless there is more serious. Yes.
Kindly turn to the application once.
Where is that?
Page 74. I'm sorry, this is my application. Section 14 application. 109. I'm sorry, 109.
Yes.
Milord, it starts at, the averment starts at Milord page 116. My lord, you'll kindly see, Milord, who is the signatory to this application. One minute, Mr. Tanmoy Banerjee. Now, Milord, there is a supplement. Initially, Milord, he did not disclose, Milord, who he is. Milord, he filed this, Milord, in his alleged capacity as the authorized officer, because only the authorized officer, Milord, can file, Milord, a section 14 application. Milord, the power is conferred upon him alone. Now, Milord, he filed a supplementary affidavit. There, Milord, he disclosed that he is the legal advisor of the bank. Milord, kindly see, Milord, the definition of authorized officer, Milord, under the securitization rules. Milord, I'll show, Milord, the supplementary affidavit once. The chotpot ball?
Authorized officer is whoever is authorized by the
no
credit.
Subject to correction, no.
Show me that.
Kindly see, Milord, the rules. Milord, 2002 rules.
Yes. Which rule, Mr. Banerjee?
Milord, rule 2, clause A.
Right.
Is defined. Has to be, Milord, a chief manager or Milord above him. Has to be. Now kindly see 107. কোনখানটায় বলেছে লিগ্যাল কোনখানটায় বলেছে যেন কোথায় কোথায়
which page
107
yes Milord 107 the first two lines before even Milord paragraph 1 first two lines he is the legal counsel
right
Milord. Yes. And Milord, one more thing. I do not know, Milord, which one will convince your lordship more. So, Milord, I do not leave, Milord, any point out. Milord, the moment I came to learn that, Milord, there is a section 14 application filed and an order passed, Milord, I applied for a certified copy. Milord, I was provided with a certified copy.
Of the section 14 order?
Application and order. Milord, in the application, Milord, the certified copy of the application, one page was missing. Milord, I indicated that. Milord, those are all annexed to my writ petition. I indicated that. Milord, the direction.
The last page.
Sorry, Milord.
Which page? The last page.
Milord, I just indicate.
That has any bearing?
That has, because Milord, after Milord, I Milord took out an application requesting the Milord learned magistrate Milord to give me Milord the complete copy. Milord, he said that Milord is missing, and he passed an order Milord passed a direction upon the bailiff Milord to give him Milord a full copy, complete copy. Before that order was Milord, it is yet to be complied with. Milord, bailiff went and took possession.
Which page was missing?
Milord, page 3 was missing. Milord, my application.
You have got a copy.
I'm sorry.
Subsequently,
no, I did not yet.
So you have annexed that.
I have not without page 3. Milord, page 143 is my application.
Check up whether by mistake you have.
No, Milord, it's not there. Milord, I have checked. At least, Milord, in my copy, it's not there. I do not know whether that's there. Milord, in my lord's copy.
14/7/23 order.
Milord, kindly turn to page 143 once.
No, 14th July 2023 is not the 14 order. Section 14
14 July 2023 is the order, Milord, which I am assailing today. Section 14 order.
So
Milord, page 3 of the application was missing. Section 14 application.
That is not it.
Milord, I just indicated to
this
lodge.
Does not convince
But Milord, there was a direction upon
your
the
learned junior thought this would convince me more than which of the juniors? The one standing. Condoned, yes. This is not convincing at all. Page 3 is missing. I appreciate that's bad, but
Milord, there was a direction upon the belief, Milord, to
no
Milord.
Authorized officer convinces me most.
Milord, these are Milord in short my submissions.
Very well.
Milord, I didn't get a chance, Milord, to assail this, Milord, though I have a statutory right. Milord, I want to go to DRT. Kindly, Milord, protect me, Milord, for a week. Milord, I will take out an application, move it, Milord, by put up petition.
Position has been taken by that authorized officer.
That's the difficult.
By the same authorized officer.
Yesterday.
Is this?
My lord, this is the instruction from the concerned PS, my lord.
But I have no allegation against police. Milord, they have carried out, Milord,
We
what
have
they have
not
been
received
directed.
any complaint from the petitioner, my lord. My lord, can you come to the second page, last third paragraph, my lord? That is
Rule dispensation under Rule 26 does not debar me from hearing you if you want to argue anything on authorized officer.
Can I take the book on?
Please, please, please. A brief apni chahiye
Yes. Take the microphone from the police, not the petitioner.
Yes,
That
Lordship.
would be more politically correct.
Lordship.
Authorized officer, convince me on
Yes,
that
Lordship.
first.
If
Yes.
I may mention, if I may come to the definition of authorized officer, Lordship.
Right.
As my learned senior friend has said, authorized officer means an officer not less than a chief manager or of a public sector bank or equivalent, as specified by the board of directors or board of trustees, or any other person or authority exercising powers of superintendence, direction, and control of business or affairs of the secured creditor, as the case may be, to exercise the powers. So any other officer or person, Lordship. And I have been
Are you
authorized by
sure
the
the
board of
legal
directors.
the council exercises this power of superintendent's direction and control of the business of affairs? It's a very peculiar predicament for Aditya Birla then.
Affairs of the secured creditor, Lordship, definitely, because the legal affairs are overseen by the legal counsel, Lordship. Number one. And number two, Lordship, I have been directly authorized by my board of directors.
You cannot be authorized. That is the point. They don't say that you have not been authorized by the secured creditor. This person has been.
Yes,
but he is not qualified under the statute or the rules to have that authority. So it's unfortunate that on this ground you have to restore the position. This is a very technical ground, but all the same hits at the root of the authority. If one is an authorized officer,
yes,
he has to have at least that authority to become authorized.
Lordship, I have been given the authority
Not
by
that
the
authority, the authority of laws. Authorized officer means you authorize and he has to be competent under this rule, Rule 2A.
Yes, Lordship. If Lordship may kindly come
As to the person, I'll direct affidavits, I'll hear
restoration of possession, Lordship, already lakhs of rupees have been spent, Lordship.
Your choice.
If Lordship may, sir, Lordship.
The lakhs of rupees, if lakhs of rupees have been spent, then I won't impose costs on you. Because those lakhs will be the cost.
I'm ready to reimburse.
Lordship.
Don't reimburse.
OTS.
Pay the
yes, Lordship.
loan.
That is my contention, Lordship. One-time settlement.
Pay the loan and tell. Why didn't you repay the loan? You are ready to reimburse these petty things and you are not repaying them.
Even the demand is not correct. I'm not troubling your Lordship with that.
Anyway. Restore person, ma'am. Authorized officer.
Kindly come to section 1312 of the Act, Lordship.
Yes. 1312, yes.
Yes. Lordship, the rights of a secured creditor under this Act may be exercised by one or more of his authorized officers in this behalf in such manner as may be prescribed.
You can go back, it's a reverse, you can go back up to Article 19 of the Constitution, I'm telling you. This is what empowers Rule 2, and this has been the statute has been formulated by the legislature under the powers given by the Constitution, and your right of business under Article 19 is being violated. But nothing in this authorizes the legal counsel. You have mentioned yourself as a legal counsel.
Lordship, if Lordship may kindly come to page 116, I have specifically said that Mr. Tanmay Banerjee, working as legal counsel, being the authorized officer appointed under section 1312.
1312 refers back to Rule 2.
1312, no, Lordship. If 1312 says the rights of a secured creditor under this Act may be exercised by one or more of his officers authorized on this behalf.
Have to restore position.
Lordship may kindly consider, Lordship, on 13th of July, they have filed the Section 17 application.
Authorized officer is not authorized. The Section 14 goes. That is the difficulty.
Lordship,
Section 14 application itself goes.
Any act, the 1312 says rights of a secured creditor under this Act may be exercised. So under the Act, Section 14 also comes, Lordship. So the legal authorized officer has exercised the powers under 1312, not under Rule 2, Lordship.
I'll record that submission. I'll definitely record that. I'll give my reasons why that is not acceptable.
Lordship, may kindly keep it after 2 hours, Lordship. I'll look through the brief and come back, Lordship.
No.
Or tomorrow, Lordship, may direct affidavits. I'll bring all facts on affidavits, Lordship.
At the outset, learned counsel for the petitioner submits that the matter has been mentioned out of turn in view of the action taken by the secured creditor stroke respondent in taking possession from the petitioner, comma, despite a notice of the writ petition being sought to be served. Full stop. Next para, it is submitted that although the writ petition and although a notice of mentioning was sought to be served on learned counsel for the secured creditor, comma, the same was refused. Full stop. Next para, an affidavit of. I'll give you reasons also, definitely.
Lordship, mentioning
not mentioning notice.
mentioning
It's not petition.
was never attempted to be served.
What was attempted to serve?
The writ petition was attempted to
Very
be
well.
served.
Sorry. Mentioning notice taken. Although the writ petition was sought to be served on the learned counsel for the secured creditor, comma, the same was refused. Full stop. An affidavit of service in that regard filed in court today is kept on record. Full stop. In view of the extreme urgency involved, comma, since the possession of the petitioner's property stroke secured assets were taken by the bank, by the financial institution, despite the petitioner having filed the writ petition, comma, leave under Rule 26 of the writ rules is sought for. Full stop. Next para. Learned counsel appeared, having instruction to appear for the financial institution stroke secured creditor, submits that she did not accept service of the writ petition since she had not been engaged at the relevant juncture by the financial institution to accept service on behalf of the financial institution. Full stop. Next para. Although such ground of refusal of service is accepted, comma, since learned counsel having no authority to accept rightly refused to so accept, comma, in view of the extreme urgency, comma, since possession has been taken, comma, the matter is taken up upon dispensation of prior service on the secured creditor under Rule 26 of the writ rules, comma, for the purpose of considering passing of interim orders. Full stop. Next para. Learned counsel for the petitioner, comma, at the outset, comma, points out that a process server was empowered by the district magistrate under Section 14 of the SARFAESI Act 2002, comma, for taking possession of the secured assets. Full stop. It is argued that a process server is not an officer subordinate to the district magistrate within the contemplation of Rule 1 capital A, Section 1 capital A, subsection 1 capital A of Section 14 of the 2002 Act.
Similar Chief Judicial Magistrate here.
Full stop. Next para. It is pointed out by placing reliance on the same provision that the district magistrate or the chief metropolitan magistrate, within bracket, the latter being applicable in the present case, bracket closed, may authorize any officer subordinate to him to take possession of assets, etc. Full stop. Next para. Learned counsel places reliance on the West Bengal District Court, within bracket, constitution of service, comma, recruitment, comma, appointment, comma, probation and discipline of employees, bracket close, rules, comma, 2015, to argue that a process server is not qualified to come within the purview of subsection 1 capital A of Section 14. Full stop. Learned counsel places the different sections of the said rules. Full stop. At the outset, comma, learned counsel points out that Chapter 3, Roman 3 of the rules deal with method of recruitment, comma, qualifications and age limit, etc. Full stop. Next para. Under category small Roman 3 bracketer মধ্যে, process establishment has been stipulated, which provides that the method of recruitment of process server in district court or city civil court or city sessions judge, etc. of equivalent rank, comma, shall be as specified in Schedule E, capital E, and the recruitment shall be conducted by the District Recruitment Committee constituted under the rules as enumerated therein. First of next para. By placing reliance on serial number 1 of Schedule capital E, comma, Part I of the said rules, comma, it is pointed out that the qualification for direct recruitment of a process server is that he or she must have passed Roman 8, capital A, 8 standard examination from any recognized institution. First up, it is argued that a person of such qualification is not sufficiently capable of dealing with an occasion where he has to ascertain what is the extent of the secured assets. First up, next para, learned counsel places reliance on a judgment of the Supreme Court reported at 2022 10 SCC 286. First up, it was held by the Supreme Court therein, comma, in the context of adjudicating whether a learned advocate was competent enough to come within the purview of subordinate officers of a district magistrate stroke chief metropolitan magistrate, comma, that while entrusting the act of taking possession of the secured assets consequent to the order passed under section 14 within bracket 1 of the 2002 Act to any officer subordinate to him, comma, the CMM stroke DM ought to exercise prudence in appointing such person who will be capable of executing the orders passed by him. Full stop. It was also observed that merely because he has power to appoint within double inverted any, inverted close, officer subordinate to him, comma, it would not permit him to appoint a peon or clerk, comma, who is incapable of handling the situation. First up, next para, learned counsel next argues that the person who affirmed and moved the application under section 14 of the SARFAESI Act on behalf of the secured creditor was not legally competent to be appointed as an authorized officer. First up, in such context, comma, learned counsel places reliance on the definition of double inverted authorized officer, double inverted close, in Rule 2 within bracket small a of the security interest within bracket enforcement bracket closed rules, comma, 2002. First up, next para, it is argued that the petitioner applied under section 17 of the SARFAESI Act at the stage when symbolic possession was taken. Full stop. As such, comma, there was no occasion or threat for the petitioner to apply for any interim order at that stage. Full stop. Subsequently, it is argued, comma, the secured creditor served an incomplete copy of the application under section 14, comma, where one of the pages was missing. Full stop. Even today, comma, no complete copy has been given to the petitioner, comma, despite an order to that effect having been passed by the competent forum. Full stop. Next para, it is further argued that the petitioner did not have any notice regarding the filing of the section 14 application and or the possibility of any order being passed thereunder. Full stop. Next para. Although service was dispensed with under Rule 26 of the writ rules, comma, learned counsel having instructions to appear for the secured creditor seeks to submit on the case, comma, in which regard she is permitted. Full stop. Learned counsel contends that the authorized officer who undertook the exercise under section 14 of the 2002 Act was duly authorized to do so within the contemplation of the SARFAESI Act and the rules. Full stop. It is submitted that Rule 2 within bracket small a of the 2002 rules has been framed under section 13 within bracket 12 of the SARFAESI Act itself, comma, which provides that the rights of a secured creditor under this act may be exercised by one or more of his officers authorized in this behalf in such manner as may be prescribed. Push-up. Learned counsel submits that the person who affirmed and filed the Section 14 application is a legal officer of the financial institution concerned and deals with the affairs of the said institution on the legal side. Pushed up as such, comma, it is argued that there was no bar in the application being filed by the said authorized officer and or an order being passed on such application. Pushed up that apart, comma, it is argued that the petitioner did not take appropriate steps despite the pendency of the application under Section 17 for a long time. Pushed up insofar as the service of incomplete copy is concerned, comma, learned counsel for the secured creditor also disputes such proposition. Pushed up next para, it is sought to be argued by the secured creditor that the said entity has spent huge amounts and resources for taking possession and, comma, as such, comma, the possession may not be directed to be restored on a technical issue. Pushed up next para, learned counsel for the state files a report authored by the police authorities indicating that the assistance given by the state was in pursuance of the order passed under Section 14 of the 2002 Act. Pushed up next para. Insofar as the first submission of the petitioner is concerned, comma, the same cannot be accepted. Pushed up next para. The entire gamut of consideration by the Supreme Court in the reported judgment was whether an advocate comes within the purview of an authorized officer as contemplated in Section 14 within bracket 1 capital A bracket closed of the SABYASACHI Act. First up, in such context, comma, the Supreme Court held that an advocate was sufficiently qualified to come within the purview of the said provision. First up, in the said backdrop, comma, it was observed further that merely because he has power to appoint double inverted any clause officer subordinate to him, comma, it would not permit the magistrate to appoint a double inverted peon or clerk, double inverted load, comma, who is incapable of handling the situation. First up, next para. It would be extremely feudal for the court if we proceed on the premise that a person having qualification of having studied up to class 8 is not sufficiently competent to give possession of the property of a secured creditor to a secured creditor. First up, next para. The context of the observations of the Supreme Court, comma, cited by learned counsel, comma, can only mean that a peon or clerk who is incapable of handling the situation will not be appointed. First up, next para. The stress, comma, in the said observation, comma, is on the expression within double inverted incapable of handling the situation, double inverted clause, full stop, and not within double inverted peon or clerk, double inverted clause, full stop, next pair. In fact, comma, the process servers, as evident from the rules of 2015 cited by the petitioner himself, comma, clearly provides that the process servers are part of the process establishment and are equivalent to bailiff stroke summons bailiff stroke seal bailiffs. First up, in the present case, comma, a seal bailiff was appointed who is specifically trained and competent to execute orders of court, comma, thereby fully coming within the clause of competence as contemplated by the Supreme Court. First up, next para. As such, comma, the said objection of the petitioner is turned down, comma, observing that the seal bailiff was sufficiently qualified and competent to be appointed by the district magistrate otherwise. First up, next para. However, comma, a more discordant chord has been struck by the petitioner, comma, vis-a-vis the extant rules, comma, when the petitioner relies on section rule 2 within bracket small a of the 2002 rules. Full stop, it cannot be gainsaid said that the double inverted authorized officer, as per the said definition, means an officer not less than a chief manager of a public sector bank, তারপর within double inverted or equivalent, double inverted clause, or any other person or authority exercising powers of superintendence, comma, direction and control of the business or affairs of the secured creditor, comma, as the case may be, full stop. Next para. The principle of ejusdem generis fully applies to, within double inverted, any other person or authority, double inverted clause, as provided in Rule 2 within bracket small a, comma, which demands that the said person or authority has to be of equivalent rank as a chief manager of a public sector bank. Full stop. Next para. In any event, comma, the definition also clarifies that the person or authority has to have powers of superintendence, comma, direction and control of the double inverted business or affairs of the secured creditor, double inverted clause, full stop. By no stretch of imagination can it be said that a legal officer of a financial institution exercise such powers as envisaged in Rule 2 within bracket small a. Full stop. Next para. The reliance placed by the secured creditor on section 13 within bracket 12 of the SABYASACHI Act is misplaced, comma, since the same clearly stipulates, comma, in no uncertain terms, comma, that the rights of a secured creditor under the Act may be exercised by one or more of the officers of the secured creditor, তারপর within double inverted, authorized in this behalf in such manner as may be prescribed, double inverted clause, full stop. The phrase, the word within single inverted, prescribed, single inverted clause here specifically refers to the security interest within bracket enforcement, bracket closed, rules, comma, 2002, comma, which has given a specific definition of authorized officer as indicated above. Full stop. Next para. Thus, comma, such argument of the secured creditor cannot be accepted. Full stop. It is palpable that the person, comma, that is the legal officer, legal counsel, double inverted the legal counsel, comma, described to be so in the section 14 application itself, comma, had no qualification under the law to be appointed as an authorized officer by the secured creditor. Full stop. Hence, comma, the entire exercise undertaken by the said person in the capacity of an authorized officer, comma, was dehors jurisdiction and without authority, comma, including the filing of the application under section 14 of the SABYASACHI Act and all steps taken consequent thereto, comma, including the order by which the possession was directed to be given to the secured creditor. Full stop. The disposition of the petitioner was a mere consequence of the said action and, comma, as such, comma, is also without the authority of law and has to be set aside. Full stop. Next para. Hence, comma, the secured creditor shall, comma, within 48 hours, comma, restore the possession of the secured assets, comma, taken pursuant to the application under section 14 of the SABYASACHI Act, which has been castigated herein, comma, to the petitioner, comma, to be restored in its original form and status as it was when the possession was taken. Full stop. Next para. The entire application under section 14 of the SABYASACHI Act and all action taken thereupon, comma, including orders passed on the same by the chief metropolitan magistrate, are hereby quashed and set aside as well. Full stop. Next para. However, comma, nothing in this order shall prevent the secured creditor to take further steps in accordance with law, comma, for taking possession under section 14 of the SABYASACHI Act. Full stop. Next para. The petitioner, the present writ petitioner will be at liberty to make further application, comma, in the event any occasion so arises, comma, for further interim orders with regard to the property in dispute. Full stop. The writ petitioner, comma, however, comma, shall be restrained from dealing with and or parting with possession of and or encumbering or transferring the secured assets in any manner during pendency of the writ petition in favor of third parties apart from the secured creditor. Full stop. Next para. The respondents shall accordingly you have filed an interim application. No, the respondents. No, next para. Since certain other arguable questions have been raised by the writ petitioner for hearing of the writ petition, comma, the respondents shall file their affidavits in connection with the main writ petition within 3 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. Full stop. The matter shall be listed for hearing in the monthly list of October 2023.
Only two submissions, my lord, on the issue of maintainability of the writ petition, my lord. One is
the question of maintainability of the writ petition is also kept open for being argued at the time of final hearing of the writ petition.
Section 14 is order of.
No, I won't entertain any argument after the matter is over.
Sorry, Lordship, if I may kindly indicate, Lordship, legal officer, Lordship has indicated that the applicant under Section 14 was a legal officer. He's the legal counsel, Lordship.
Legal officer একটা জায়গায় না দুটো জায়গায় বলেছি legal counsel কবে অন্য জায়গায় legal counsel.
And Lordship, in another occasion, Lordship has said that the secured creditor did not served an incomplete copy of the Section 14 application. Lordship, we were not directed to serve. They had applied for a certified copy. The office of the
Very well. যেখানে বলেছি দেখবেন secured creditor did not supplied an incomplete copy of the application. সেখানটা একটু করে দেবেন. The office of the chief metropolitan magistrate.
Chief judicial magistrate.
Chief judicial magistrate. Metropolitan হবে না judicial.
At one place it has gone
yes,
down.
Yes, I'll check. Grateful.
So grateful. Not extremely grateful.
Thank
to
you,
your lordship.
Next.
ম্যাডাম আমি বইটা নিলাম
মাধবা বুঝলেন তো চিফ মেট্রোপলিটন হবে না চিফ জুডিশিয়াল ম্যাজিস্ট্রেট হবে আর ওই যেখানে কপিটা দেয়নি ইনকমপ্লিট কপি দিয়েছে ওটা অফিস অফ দ্য চিফ জুডিশিয়াল ম্যাজিস্ট্রেট
সাপ্লাইড এ কপি অফ দ্য
থ্যাংক ইউ yes
great
upgraded matter item 5
yes
yes for the petitioner. This is a case of the petitioner being deprived the industrial promotional assistance which has been approved in his favor and which he has already been paid for.
Mr. Sen, can you please do you recollect your date of enrollment?
Mine?
Yes.
Yes.
If you, if you remember that, please, can you ask your junior to write it on a piece of paper and give to my officer? It ekটু দিয়ে দিও তো আমাকে. Yes. Please continue.
Yes. Well, this is an industrial promotional assistance.
Right.
Approved by the government by orders. Not only approval, I have got it for 2 years. For 2 years full amount, 3 years half amount.
Yes.
I am entitled to get it as per their order for 5 years.
Right.
So 5 years and 2 months.
Yes.
So my lord, I had approached this honorable court earlier against their refusal to grant me for the remaining period.
Yes.
There was an order passed that they will hear me and an order has to be passed. So that order has been passed where they purport to justify their action on the basis of subsidy scheme. Now, I am going to show your lordship that, first of all, the order by which this IPA was approved has no nexus with subsidy scheme. This is a special package. It only says that I will be entitled to this grant and all other subsidy except interest subsidy. So my first submission will be there can be no reference to any subsidy scheme for justifying my refusal. And second argument will be, without prejudice argument will be that even assuming that the subsidy scheme is applicable, because the approval order mentions a 2000 subsidy scheme, they will have to refer to 2000 subsidy scheme to justify refusal. They have gone to 2004 subsidy scheme for the purpose of justifying refusal. So these are the 3 points which I will argue for the purpose of showing that this order cannot stand. My lord, kindly see, my lord, first the two orders by which approval was granted to me. Kindly see page 147 first. 10th of August 2005.
Yes.
Their internal communication, but says special package of incentive as detailed below had been sanctioned in favor of Ambuja Cement Eastern Limited for its proposed unit at Sakrel, Howrah, with an investment of 33 crores for the purpose of manufacturing cement. Package 1, I am not placing 1 and 2 because there is one modification at page 148. I relocated my unit to Farakka. That has been considered page 148. Third paragraph. After careful consideration of the facts and circumstances of the case, it has now been decided to extend the package as below to this unit even after relocation at Farakka. So now my present unit is entitled to this package. Number 1, my lord, industrial promotional assistance at the rate of 75% of VAT paid in the year previous to the year during which IPA would be released without any financial cap by way of adjustment against VAT liability of that year. That means I will have to show what is the VAT I have paid for this year. 75% of that amount I will get as a package in the next year. This is the, my lord, special assistance. VAT will not include VAT paid on the purchase of raw materials. This will be available for a period of 10 years if commercial production commences within 31st December 2005, for 8 years if commercial production such and such. Period may be decreased depending upon the commencement of commercial production. Next line, my lord, para is important. Units will be entitled to all other subsidies as laid down in 2000 scheme except interest subsidy. That is why I want to make a distinction between 1 and 2. 1 is special apart from 2000 scheme at all. But says, despite grant of IPA, I will also be entitled to all other subsidies under 2000 scheme.
Apparently, you don't come within 2000 scheme.
Yes.
But those subsidies apart from it,
(153) is the table which shows the period for which I will be entitled. Kindly see statement A, showing the period for which IPA would be allowed depending upon the commencement of commercial production. My lord, 1, 2, 3, 4. Fifth entry from the bottom is mine because my commercial production has been commenced on 31st of May 2007.
This is for the 5 year, 2 months.
Yes, 5 year, 2 months I will get.
Great.
Well, page 161. There is a slight modification in this package. Yes. Page 161.
Yes.
Now this says, I will be kindly see Roman 1, industrial promotion assistance at the rate of 75% of VAT and central sales tax. So CST is now added. Whatever I pay CST plus VAT, 75%.
Everything else remains the same.
Everything else remains the same. And only one thing, kindly note, they have also recorded here in the first paragraph that Ambuja Cement proposed to set up a cement manufacturing in Murshidabad in and around with an investment of 100 crores. Kindly keep a note, I will come to that later. 2nd March 2006, they have noted my investment is 100 crores.
164 clause 30.
Kindly come to
164 clause 30.
Clause 13. Yes, this is this entire package has been with the concurrence of the finance department, wide number such and such, read with this is the finance department has their approval. Yes. Now kindly comes to my lord page 180. Yes, this is a very important one. 180 is the eligibility certificate that I am eligible for this.
Yes.
Kindly see, my lord, we enclose eligibility certificate number such and such dated 18 May 2010 under West Bengal Incentive Scheme 2000, whereby your unit is declared eligible for the following units. State capital investment subsidy. Now, B is the industrial promotional assistance. I am only.
What was the date of this scheme? The one which we are on?
2000 scheme.
Both 2000.
Both 2000.
No, it refers to the West Bengal Incentive Scheme 2000. That was a different scheme.
No, same scheme. Package, well, kindly see, eligibility certificate covers capital investment subsidy.
No, the argument you made that this does not fall within the
That is,
WPIS.
this is a special package. My argument.
Oh, you said this is a special package,
Special
not
package.
that scheme.
Not scheme.
Wait.
I am entitled to that scheme, subsidies under that scheme, but this is
Except
something
interest.
separate.
Right. Yes.
An eligibility certificate is in relation to all sorts of grant. It is not related. The eligibility certificate is not concerned only with IPA. It is for all grants. Kindly see, eligibility certificate is for the following incentives. Number one, state capital investment subsidy. That may be guided under the subsidy schemes. I am concerned with B, industrial promotional assistance at the rate of 75% of VAT and paid in the previous year. This is that, two orders, special orders. And what is important, here is the print is very small. Last line, without any cap.
What It's very legible. We can read, Mr. Shen can read, and I can read, you can definitely read.
I'm saying it, Mr. Singh. My learned friend
I'll
wants
overhear you.
that I must not go further so that the admissions are not shown. So, this subparagraph B is the promotional assistance is without any financial cap. That is one very important thing. Then, waiver of electricity duty and employment generation subsidy. I am not concerned here, but I am eligible. This is an eligibility certificate. Then, your lordship will kindly see. Yes, straight away, your lordship can come to one thing. Annexure to the eligibility certificate at page 185. This will also show the period for which I am eligible for the promotional assistance, serial number 2. Released by adjustment of VAT and CST for a period of 3 years, 2 months from the date of commencement of production. Kindly note, they have mentioned it also 31st May 2007. Now, yes, 5 years, 2 months from 31st of May 2007.
Right.
Now, kindly come to page 196. This is the admission.
That illegible portion.
Yes.
No, illegible acronym is I can read.
I will read it aloud for my
He cannot read, so yes. 196.
196.
Right.
With reference to the certificate issued by the Commissioner Commercial Tax West Bengal for Indian Industrial Promotional Assistance Order WBIS 2000 for your project for manufacturing of such and such cement located in the district of Murshidabad covered under eligibility certificate. We would like to inform you that this corporation has admitted 628.22 lakh for the first year, 2007-8, 1443 for the second year, 2008-9, and 3518.76 for the third year towards industrial promotional assistance and adjustment of such and such for the first year. These are the adjustments. After adjustments, these are my admissions. Now, here, your lordship will kindly note, first year, entirety has been released. Even the second year, entirety has been released. Dispute starts from the third year. We have got 17 crores out of 34. And for 2010, 11, and 12, 13 up to 31st of July, there has been no sanction. As per this order, no, the question of disbursement does not arise. Now, I straight away take your lordship to the order by which they have purported to justify that I am not entitled to any further. Kindly come to page 72. Kindly see at 73. Towards the bottom, my lord, I'll place their observation. The observations are the following.
Yes.
After careful scrutiny.
This is pursuant to Justice Bossak's order.
Yes, may I just show your lordship once the order so that it will.
No, Justice Bossak's order I've seen.
Yes.
So this is pursuant to that.
Yes, yes, pursuant to
yes,
that.
Yes.
Petitioner company Ambuja Cement was given special package of incentive and allowed to enjoy the benefit of industrial promotional assistance rate of 75% value-added tax central state tax paid in the previous year. It was asserted that IPA will be released without any financial cap by way of adjustment against VAT and CST liability of that year only. The petitioner company was released 41 crores as IPA against fixed capital investment of 41 crores as assessed by disbursing authority. This is the first point where I say fixed capital investment of 41 crores, that is palpably wrong, because in the order of page 161, they themselves say it is 100 crores. I have made an investment of 100 crores. That is why the special package is being given, VAT and CST, 75%. Without going into any further documents, I have my CA certificate also. But I first rely on their own statement. Of 2006, it was 100 crores. Next, my lord, kindly see.
What is the page number of that?
Yeah, 161.
Yes.
161.
Yes.
Paragraph 3, it appears that the petitioner company is aggrieved for alleged non-disbursal of incentive amount beyond FCI limit, that is 41 crores. Now, this is 41 crores is disputed. It also appears that the deed and principal secretary in office asked for few documents and it has submitted those documents by reference. Now the documents have been submitted. To come to any conclusion, it is pertinent to refer to the said order dated 2nd May 2006, based on which the IPA was granted. That is page 161.
Right.
Now they are quoting, my lord, Roman 1 and Roman 2, which I have placed. Now kindly come to para 5. Further, as per para 9 of the order dated 2nd March 2006, which they quote, in addition to industrial promotion assistance, an amount not exceeding 15% of the VAT and CST paid in the previous year will be released in the manner as indicated above as adjustment against admissible amount of capital investment subsidy and employment generation subsidy for a period of 10 years. I do not know, my lord, why they are referring to para 9, because my claim is not in addition to industrial promotion assistance. Para 9.
Probably wanting to introduce that financial cap for that.
Yes.
Para 9 is.
They are referring to para 9, which relates to different subsidies,
yes,
which contains a provision for financial cap. They want to link it up with industrial assistance. I am not concerned with para 9. Industrial assistance is para 1 and 2, and it has no nexus with para 9. 1 and 2 specifically says without any cap. So, my lord, thereafter, now kindly see their interpretation of 1 and 2. Reading 1 and 2 of the said order together, it is amply clear that IPA package was granted in lieu of interest subsidy. Maybe it's not in lieu of.
Yes.
IPA is separate. All other subsidies under 2000 scheme, I will get except interest subsidy. Roman 2.
Yes.
So, my lord, it is definitely not in lieu of. It is also relevant to note that at the time of issuance of the order, annual interest subsidy was capped at 100 lakhs per year, and by virtue of the said order, interest subsidy was uncapped, decapped, made without any financial cap. This I will try to show. They are taking recourse to 2004 subsidy scheme to come to this interpretation, which in my most respectful submission has no nexus. Roman 1 is separate from Roman 2 regarding IPA. Therefore, next page, well, page 75, therefore, prima facie, the said order is clear to the effect that IPA was granted to decap the interest subsidy. I do not know, my lord, how this comes. Hence, it may be inferred that IPA package has raised the incentive above the schematic cap of that time of interest subsidy and capital investment subsidy. Then again, my lord, para 7 goes to further para 9 of the order of 2nd March 2006. They have quoted para 9. I do not, I skip that. Then I come to the next para. In above, again, abundantly clear that beyond capital investment subsidy, IPA is valid for a period of 10 years or till financial cap is reached, whichever ends earlier. Now, this probably cannot be interpreted because 9 is separate. I am not claiming 9. Now, my lord, paragraph 8 is important. Kindly see, observations of finance department dated 28th December 2018 also perused and relevant portions are as below. But kindly note, this finance department observation was never disclosed at the time of hearing. I had no knowledge of this. This finds place for the first time in the order. This is my case at page 43, subpara L of the writ petition. And there is no denial to that. Now, without prejudice, let us go into these observations of the finance department also.
Affidavits have not been directed in this.
Yes, they have filed
that
affidavit. Yes. But this kind of an order,
yes,
they cannot go, your lordship knows, my lord, they have to justify the order on the strength of the reasons contained therein.
Right.
Oh, but the reply is just maybe kept on record. I have already served them. Yes.
You have filed your opposition.
The erstwhile advocate may have filed, my lord. I don't know.
That's obvious. Record.
I can give a copy, my lord, if for the completeness of the.
That's why.
Then I cannot rely on the reply.
No, that is what I said. My lord, that is the difficulty. It's a change.
Very well, in lordship.
State has not changed. State remains state of West Bengal.
I cannot say anything on that.
You have changed.
Now, if your lordship comes to paragraph 8,
yes,
what was the observation of the finance department? It is evident from the packages granted to 3 cement manufacturing units that they were granted IPA in lieu of interest subsidy under the relevant scheme. Now, first of all, my lord, whether IPA is not granted under the subsidy scheme. In both 2000 and 2004 scheme, there was a limit of 100 lakh per year in respect of interest subsidy only. So therefore, you are trying to make it a cap in IPA also. As IPA is related to VAT CST paid in a particular year and it was allowed in lieu of interest subsidy, it could also be interpreted to have the same per limit of 100 lakh as applicable for interest subsidy. By implication, they are trying to say that since interest subsidy has a...
But interest was dissociated, interest subsidy. That was the reason probably interest has a cap.
Interest has a cap.
Yeah. But this does not. That was the reason, one of the reasons for dissociation.
Exactly. And that was also the reason to say that you will get other subsidies in lieu of interest.
They are saying in lieu of interest now.
They are saying
it was not originally in lieu of interest.
No, it was not.
Apart from interest.
Apart
something like that.
Yes.
Very good.
Now your lordship will see.
Shane, I'll continue after 10.
Yes.
10. Yes.
Yes, my lord, your lordship comes back to
Yes.
page 75.
Right.
Kindly see B. So it is evident that reference like without any financial cap in the packages has always been made only in the context of payment of IPA per year, so as not to invoke the limit of 100 lakh per year in respect of interest subsidy under scheme in lieu of which IFP has been also. Entire basis is it is in lieu of interest subsidy. This reference has nothing to do with overall limit of total amount of incentive. Nowhere in the packages allowed to the aforementioned three companies that has been provided there would be no financial limit respect of overall amount. This is all the more relevant in the context of specification of overall financial limit in para 20 Roman 3 of WBIS 2004. So they are actually relying upon the 2004 scheme and the provisions contained therein to bring two things, that it is in lieu of interest subsidy and therefore financial cap will apply. So therefore, this is my submission that there cannot be linked with 2004 scheme at all. Next, kindly sees. Then, my lord, if your lordship kindly comes to last part. After careful consideration of the issue, I hereby order that petitioner company was not entitled for incentive in excess of fixed capital investment limit at any point of time, and the so-called without any financial cap only signifies no capping for IPA in lieu of interest subsidy of a particular year only. So therefore, their order is contrary to para 1 of page 162. This is number one. Number two, I'll take the alternative argument that 2004 scheme cannot be made applicable at all. Yes. Well, I am relying upon, I'll give you a lordship the 2004 scheme. I'll also speak with my learned friend. Amar kache ache no. Yes. Kindly see clause 5 first. 5.1. Non-applicability of the 2004 scheme.
Yes, yes.
The 2004 scheme shall not be applicable to those industrial tourism projects that have been registered for and have been sanctioned incentives under any previous scheme. So if it is their case that IPS is part of 2000 scheme, then page 196, I have already got disbursement for 2009 and 10. And therefore, admittedly, under 5.1, 2004 scheme cannot apply. Now, kindly see 20E, which they have relied upon. At page 17 of this one. It is part of the definition of mega project under E.
Yes.
E Roman 3. Value of total incentive shall not exceed 100% of the fixed capital investment in any case. So this has been bodily lifted by them and made to 2004 scheme applicable for disallowing this. But I have any event shown my FCI is higher than 100 crores. Yes. Then, so your lordship, so these are my points of challenge to this order. Number one, it is a special package not governed by any subsidy scheme at all.
Yes.
The reference made in the eligibility certificate to the subsidy scheme 2000 only for the purpose of the fact that under the subsidy scheme, mega projects are entitled to special packages. And I am following it as a mega project, and therefore special package was sanctioned in my favor. Irrespective of subsidies under the subsidy scheme of 2000, but all those subsidies will be granted except interest subsidy.
Very.
So now, only one thing I just want to show, paragraph 38, where I have said this is the amount which has fallen due. Paragraph 38. Yes. 2000, at page 28, your lordship will find a table.
Yes, table.
Kindly see 2007, 8 and 8, 9, there is no dispute. I have received the entire amount. 2009, 10, I have received 17.53 out of 35.18. There is also no dispute regarding this amount. Now 2010, 11, 11, 12, your lordship will kindly see 43.38 is my entitlement. I just want to show your lordship from the certificate issued by the Directorate of Commercial Tax, what is my entitlement and the calculation that it is in terms of this, because 75% of VAT plus CST is my entitlement. Now, if your lordship just takes page 238 of the writ petition, your lordship will see it is a certificate from the Commissioner Sales Tax. If I may read the second paragraph only.
Yes.
With reference to applicant's petition for issue of certificate, report is received from such and such. It transpires from the report that during the period 10-11, output VAT payable was found to be 52 crores or ITC adjusted by the petitioner was such and such. Hence, kindly note this, net VAT paid was found to be 52 crores 5,62,286 and CST payable was 49 lakhs. And adjusted 49 lakhs 77,821. Now, my lord, 75% of this amount will work out to 39 crores 41 lakhs 55,080. This, there is just one correction. Instead of 43.38, which I have calculated at page 28, this will work out to 39 lakh 41,000. I have this correction.
39.41.
39.41. But I have placed by way of made the correction by a supplementary affidavit to be on the safe side. At a copy here.
The rest are there. And the rest are all right.
Rest are all right.
Great. So what is your total due you have quantified in your prayer?
Total due, my lord, therefore will be, if your lordship
addition of these amounts, pending incentives.
Only, my lord, last column,
yes.
2010, 11, 11, 12 and up to April 12.
The pending incentive is the one which is
yes,
stupid.
17.65 also to be added.
Yes, the entire right-hand column.
Yes, it will come to 118 crores. Your lordship will see the supplementary affidavit, the final figure.
Yes.
Yes. The para 38 shows
right,
121.
Right. Yes.
It should be 118. This is there. As per the Directorate of Commercial Taxes certificate. There is no dispute raised with regard to that. These are my submissions. Yes. I would only be praying, my lord, your lordship will quash that order and direct them to release this amount. Obliged.
Why do you say only? What remains, Mr. Sen? Yes. Yes, Mr. Chakraborty. Read yes. The fine prints.
My lord, may I just in?
Yes.
Well, there is an incentive scheme that was extended to the petitioner company.
You start with the philosophy of
no, just I will come to them. Just I'm already on a sticky ground.
What, no, very well. Yes, please.
May I just kindly allow me?
Do this. Yes.
Well, incentive schemes. Certain benefits were extended to the incentive scheme. Subsequently, my lord.
Only one question, Mr. Chakraborty. I couldn't resist this. Is this on instruction or extempore? Cannot be on instruction. Yes. Incentives?
My lord, we tried to talk to the concerned officer, my junior. He said he is on holiday due to Rakhi.
You should be on holiday listing.
That's right. My lord,
No, the most valiant are
very difficult.
the most valiant persons are the advocates who appear for these authorities and state and all these. I mean, they're most valiant. I mean, don't know what they have to go through. I somewhat know. I mean, because I was there.
My lord appeared for Union of India for some.
Yes, yes.
My lord, a scheme was envisaged or extended to the petitioner company. My lord, certain benefits were.
Don't make it too long, Mr.
No. Just I'll take 2 minutes. I'll take you to the documents.
Right.
My lord, now an order was passed by this honorable court to consider their application, which is at page 207. We had the application is at page 207, which was considered. Well, an interpretation was given. The interpretation was given on twofold grounds. One was whether, my lord, the 2004 scheme has been completely excluded from the scheme of the things, because the order page at 161 is of 2006, while this 2004 scheme had already come into play. I'll show, my lord, I'll come to that. 161 pages of dated 2006. So, my lord, can it be said that
can it automatically come in? I mean, they have to apply under a particular.
I'll show, my lord. I'll show, because I'll show, my lord, kindly one. And another aspect, my lord, would appreciate what is their case.
You're for the state.
Yes, they are saying I have extended the benefit to you. I have acted on your promise that you will extend this benefit to me. Now you cannot resile from the step. My lord, one of the points taken, my lord, which was not placed before my lord, was that if this is allowed, this would be against the public at large. This particular benefit. My lord, this is there. My lord, good, bad, indifferent, this is there, my lord. This is there in the order. My lord, at least there are judgments of the Supreme Court.
That's a common refrain.
My lord, if it is also, my lord, they ought to have said this is a incorrect stand taken by the respondents. They could have said, I do not find that pleadings in the writ petition. Well, I'll come to
what
that.
What is your best point, Mr. Javas? Stick with that.
My lord, I'll stick to it. My lord, would kindly come. My lord,
what is your best point? Tell me that.
No, I say, my lord, there are 2 points. But the interpretation, it is an interpretation. If there is no manifest arbitrariness in that interpretation, my lord possibly would not go into in a writ petition. Second is, my lord, the 2004 scheme has not been excluded, and the 2004 scheme has indicated a cap. I'll show, my lord, how it is applicable. How? Because when all the other benefits were under 2000 schemes. I'll show the language used in the first paragraph for the IPA, Industrial Provisional Assistance, is absolutely the same language that is adopted in 2004 scheme.
So regarding interpretation, your interpretation point, if you want to cite any judgments, you can, or if you don't want to cite, no.
I'll cite the judgment. Let me first place the facts. My lord, kindly come to page 161.
161. Yes.
My lord, the learned senior friend had said that 100 crore they have invested. This letter, when was written, it was, kindly see the first line, Ambuja Cements Eastern Limited has proposed to set up a cement manufacturing unit at Murshidabad in and around Farakka with an investment of 100 crore.
They've earmarked that.
Yes, but they would invest this. So I'm saying, they have invested, but they have invested. Whether they have invested or not, that has to be gone into the record.
Yes.
But that is what. But kindly see the first two.
Mr. Banerjee is appearing in this matter.
Yes. I'm sorry.
Leading you.
Yes.
I'm sorry, Mulad. I just, since
Mr. Banerjee
did a better job than Mulad, I could have done not being there, Mulad.
The right thing, Mr. Banerjee. Absolutely. Fair of you. Yes.
Mr. Banerjee.
No, fair enough for him. Yes.
May I just place 2 or 3 facts?
Yes.
One. Industrial promotion assistance at the rate of 75% of the VAT and the central sale tax paid in the year previous to the year for which IPA would be released without any financial cap by way of adjustment against VAT and CST liability of that year. The VAT and CST will not include VAT and CST paid on the purchase of raw materials. This will be available in the scale detailed in the enclosed statement A. The unit will be entitled to all other subsidies as laid down in the West Bengal subsidiary scheme except interest subsidy. My lord, when all other subsidy possibly, my lord, would exclude this also. Interest, because the first argument my Mr. Sen has made was that this entire scheme, this package was outside the scheme of the subsidiary schemes.
Yes.
That was the first.
Where is the question of reference to that scheme? Only something which is outside can refer to something else.
My lord, I say, my lord, this IPA, I mean, I'll show the language because I am drawing inspiration from the 2004. But there has to be a scheme, but there has to be a specific scheme to be extended to the manufacturing units. There has to be, well, I'll show the judgments. My lord wanted the incentive scheme. If there is any ambiguity, it goes to the revenue to decide. It will be has
yes,
to
on that you are
yes,
required to cite judgments. Yes.
Yes, well, there has to be. But I say, my lord,
yes,
at least there is nothing to show that the 2004 scheme has been excluded from the scheme of the things. But that is my argument. My lord would kindly consider this.
Does it operate automatically unless it is excluded? Some scheme will come in the year 20.
No, 2004.
In the year
this
2000.
Is a manufacturing unit which has started its operation in after 2004 would be covered by the 2004 scheme.
I start an operation, I come under a scheme, I apply, I get that, and I never know whichever scheme you may float subsequently that will apply to me. That would be very beneficial for the units.
No, that is 2006 scheme. This is a letter of 2006. I am saying about a scheme of 2004 which has come into play. It is not a scheme that has come into play subsequent to this notice. I am not saying that, my lord. I am not saying that they were given by a surprise. They were aware that there is a 2004 scheme. And that is what I am saying. My lord, the 2000 scheme, my lord, would find in that.
So you stress on the point that this letter was this document was of 2006.
Yes, but that is one. The second
That
was
was
2006. One that
but the scheme in consideration is 2000.
Scheme in
That's a special
consideration for all other subsidies is, my lord, they have made a bifurcation.
All other subsidies.
My lord, the units with all other subsidies as laid down in the 2000 scheme except interest subsidy. My lord, this particular portion they have also agreed that this does not come under the 2000 scheme. This particular one. That's why I'll show my this comes under the 2000. If the same language, if absolutely the same language has been adopted, but that interpretation has been made. That is what I'm trying to justify that interpretation. Now, my lord, vis-a-vis this letter, vis-a-vis the order passed by the concerned authority. My lord, kindly see. Allow me to place it entirety.
No.
Then
highlight the portions you want to rely on. Don't place the entire order.
No, I'll start from page 74.
An absolute waste.
No, page 74, man. Five.
Yes.
Now the said document has been submitted to come to any conclusion. It is pertinent to refer to the order dated 2nd May 2006, which is the page 161,
yes.
On which the said IPA was granted. Point number 1 and 2, para 2. Industrial promotional assistance at the rate of 75% of the VAT and the central, it is a reiteration. Further, as per para 9 of the said order, in addition to the industrial promotion assistance, an amount not exceeding 15% of the VAT and CST paid in the previous year will be released in the manner as indicated above, so and so, must subsidy for a period of 10 years or till the financial cap is received, whichever ends earlier. Reading Roman 1 and 2 of the said order together, it is amply clear that the IPA package was granted in lieu of interest subsidy. Because when an interest subsidy was...
How does 9 come in at all?
Well, but they are trying to basically say that subsidy, if this is considered as IPA as a subsidy, there has to be a particular capping to it.
Obviously, they're trying to do that.
That is
what is the relevance of para 9 in their case at all? Para 9 says in addition to the industrial promotion assistance, an amount not exceeding in the previous.
Last two lines, because both this issue relates to the VAT and CST. 75% and 15%. And the last two lines, subsidy. This word subsidy, they are emphasizing that this would include everything. This would include the IPA also.
Because previous years, the amount not exceeding, this is regarding the release of the previous year's dues.
Yes, well, that is the scope.
That has to have a cap, which is till the financial cap. 10 years or?
If there is a cap.
This cap pertains to this period of 10 years. Which will be the outer limit of paying the previous dues.
Well, that is the interpretation possible.
That is the interpretation.
Yes,
they are challenging that interpretation.
Yes, they are saying that this subsidy excludes the IPA, industrial promotion.
What is your argument on this? Let's forget their interpretation.
No, I'll come to that. I'll come to that. How this has been interpreted. This is more or less the submissions. Kindly see. Reading 1 and 2 of the said order together, it is amply clear that IPA was granted in lieu of interest subsidy. It is also relevant to note that at the time of issuance of the order, the annual interest subsidy was capped at a ceiling of 100 lakhs per year. And by virtue of the said order, the interest subsidy was uncapped, decapped, and made without any financial cap. Well, this is in both the scheme, there was a financial cap against interest subsidy in both the scheme.
Interesting.
Therefore, prima facie, the said order is clear to the effect.
Chakravarti, make your arguments. Don't read the entire order.
No, kindly allow me just 2-3 minutes. I will not.
You're fishing out arguments during the course of
kindly, allow me. I'll not take more than another 5 to 7 minutes.
Not a question of 7 minutes, Mr. Chakravarti. Why deprive the others of those 7 minutes? I mean, what are your arguments?
I possibly have something. That's why I'm reading. Possibly, my assessment, it may be wrong.
Assumption is it is wrong, Mr. Chakravarti. Anyway, please.
Therefore, prima facie, the said order is clear to the effect. The IPO was granted to decap the interest subsidy. Hence, it may be inferred that the IPA package has raised the incentives above the schematic cap of that time of interest subsidy and capital subsidy. Further, para 9 of the said order dated so-and-so, in addition to the so-and-so subsidy, I do not want to make any submission on this. In the above, again, abundantly clear that beyond the capital investment subsidy, the IPA is valid for a period of 10 years or till the financial cap is reached, whichever ends earlier. Hence, the original government itself summarizes that the decapping occurs for interest subsidy, but the total IPA is still under the financial cap. But that is the argument, interpretation. The observation, this is I'm relying on heavily. The observation of the financial department dated so and so also perused, and the relevant portion are as follows. It is evident from the package granted to the 3 cement manufacturing units. Here, they were considering a situation. The 3 manufacturing units were extended with certain benefits. Now, whether this is feasible or not, if it is subject to correction, if today the government feels it is not feasible for them to extend the benefit anymore, can my lord again impress on the basis of the second May? That would be my argument.
I don't get your point. Yes.
If today it is,
if the government decides.
No, if it is found to be not feasible, this particular benefit.
Found by the government to be not feasible.
If today.
Midway during the scheme. Midway during the disbursement.
Yes, my lord, if today they can always withdraw it, they can always withdraw. I'll show the judgments to that. I can always. These are incentives.
Don't threaten me. I'll show the judgment. What is your take?
That is
your argument.
My argument is incentives.
So the state, have I understood you correctly? You say that the state during the subsistence of a scheme can always withdraw it.
Subsistence or subsequent, when the payment, kindly appreciate.
No, this was during subsistence.
Yes, no, this is 2018. This is subsequent. This is in the nature, I would argue, this is in the nature of a clarified.
Have you withdrawn the scheme at all?
No, this scheme has been, this is
an irrelevant argument.
No, I'll tell you, this has been an interpretation made not only for them, for 3 other cement companies where this particular benefit was.
The other 2 are, waiting for this matter.
Possibly, may I just place it? It is evident from the packages granted to the 3 cement manufacturing units that they were granted IPA in lieu of interest subsidy under the relevant scheme. In both the 2002-2004 scheme, there was a limit of 100 lakhs per year in respect of interest subsidy. As IPA also related to VAT CST paid in a particular year, and it was allowed in lieu of interest subsidy, it could not be interpreted to have the same per year limit of 100 lakhs as applicable for interest subsidy. So it is evident that the reference like without any financial cap for the package as always being made only in the context of IPA per year, so as to not to invoke the limit of 100 lakhs per year in respect of interest subsidy under the scheme. in lieu of which IPA has been allowed. The reference has nothing to do with the overall limit of the total amount of incentive. Nowhere in the package allowed to the aforementioned three companies that it has been provided that there would be no financial limit in respect of the overall amount of incentives. This is all the more relevant in the context of specification overall financial limits in para 20E Roman 3 WBI 2004. The value of total incentive shall not exceed 100% of the fixed capital investment in any case. Moreover, the incentive schemes were formulated to encourage capital investment in the manufacturing sector of the state, which provided for subsidy incentive to cover full 100% of fixed capital investment of the unit. So the package of the incentive allowed it, any particular should not be so interpreted as to override the general intention of the relevant incentive scheme, considering the socio-economic rationale behind such scheme. The interpretation should not be contrary to the public purpose of the state so as to severely restrict its resources to provide multimodal citizen-centered services, including provisions of public good and other development needs for the common man. Hence, the view of the financial department. This is the view of the finance department. This has not been challenged. They say a copy has not been given to them.
Chakravarti, remember about the common man when disbursing the money on schemes, and you don't worry a second time when you float these schemes, that too publicly on public forums. It's very easy to float schemes and say that we are so congenial to economy. When it's that the turn comes of paying the money, you remember about the common man.
Absolutely, that is the difficulty. Today, would appreciate this if this is a specific observation which has not been challenged.
Is this reasonable? Is this interpretation? I mean, you speak about the 2004 scheme, 2000 scheme.
2004 scheme, 2000. This is a 5-year scheme. All the other payments have been made. It is not electricity duty that has been.
Yes. What else?
I'll just show the judgment. 2004. Would kindly come to 20, which was relied upon my learned senior friend.
What 20?
20 of the 2004 scheme.
Yes.
Roman 1. Mega projects will be entitled to all the benefits as provided in the WBIS 2004, excepting interest subsidy. In lieu of interest subsidy, such projects will be entitled to industrial promotion assistance. But the reasons has to be the common. That is my submission.
Reasons have to be?
The reasons has to be the same. Why this? Because a lot of submission was made that it is not in lieu of the interest subsidy, but possibly it is not right, because this scheme actually advocates such facts that this particular thing it is in connection or in lieu of interest subsidy. Now such projects will be entitled to industrial promotion assistance at the rate of 75% of the sales tax paid in the year previous to the year for which the claim would be made. IPA should ordinarily be allowed to mega projects for such period not exceeding 15 years by way of adjustments against current liability as the state government may decide in any particular case. But the limit is 100% fixed capital, that is Roman 3. But I say this has this particular subsidy scheme. That's why the petitioner started with the argument that both these schemes are not applicable to us. This is a special package. I say, although it is a special package, but this spirit this letter and spirit specifically states, and this is an industry which has come up after 2004. This is after 2004, the special benefits were given, and this interpretation, if the authority concerned
from 2004, Mr. Chakravarti, there are no other schemes.
They all 2000.
If there are other schemes, why shouldn't they also follow? They also apply.
They are applying under this particular special packages.
Whichever clauses of each of the schemes suits you, you apply that.
No, I am saying
then apply the rest of the scheme.
No, IPA, this IPA, the issue is only restricted to the IPA. I would appreciate this issue is, and I am saying why the IPA was granted.
What is the full form of IPA?
Industrial Industrial promotion assistance.
So that's a special package.
That was a special package, and the power to give that power comes from this.
Power you have already exercised.
But in 2006, I have exercised. I say it is in connect. I have exercised the power under the 2004 scheme, and under the 2004 scheme, there is a capping. That is, the case is only now is boils down whether there is a capping or not. I am saying there is a capping. You cannot ask for more than the fixed capital investment. I have relied on 3. They say, no, this particular 2004 scheme is not at all applicable. I say, when the scheme, this particular industry has come up, this particular scheme is the only scheme that was available to them. And what the special package, if anything, was granted, there has to be a power. Exercise of power, when there is a particular power,
yes.
That's power, man. That is my submission. And I say this is a reasonable interpretation by the concerned authority.
Very
reasonable. 2 judgments.
Yes, side the judge.
To bar for 572. Judge. No. বলছি দাদা পেজটা বার করে এমনি ঘাবড়ে গেছি 98 ভলিউম 1 ঘরে খবর কারণ নেই না no 98 1 SCC 572
This is on the interpretation issue.
This is on the issue whether a promissory estoppel when there is a public at large is I'll show the next judgment on interpretation. Kindly see the 3 and 4 of this judgment.
Give the citation for
98 volume given
in the microphone.
98 volume 1 Supreme Court cases 572.
Mr. Banerjee also. That's why.
Oh, I tendered apology to him. Paragraph 3 and 4.
Right. Yes.
The sale tax officer took the stand that there was no notification in force.
The mic, Mr. Chakut.
Please, I tender apology.
Yes.
Section 6 of the Odisha Sales Tax Act provides that the state may, by notification subject to such conditions and exception, if any, exempt from the tax on sale or purchase of any goods or class of goods, and likewise withdraw any such exemption. A notification dated 11 November 1969 has been issued under Section 6 by the state government, by which raw materials which went into manufacture of the finished goods were exempted from sale purchase tax when such goods were sold to a registered dealer. But this was withdrawn. This particular benefit, I'm not good. Facts, this was withdrawn.
So para 24 is the crux.
16 to 24, 16 to 24, 24 is the crux.
Very
good. Kindly allow me
16,
to
right?
17, 17, my lord. I'll just
17.
Yes, my lord.
Yes.
Moreover, it is well settled that any IPR can be changed if there is an overriding public interest involved. It has been stated on affidavit by the state of Odisha that after a package of incentive was given to the industries, the government was faced with severe resource crunch. On a review of its financial position, it was felt that for the sake of the economy of the state, it was necessary to limit the scope of exemption granted to various industries. Accordingly, further notifications were issued under Section 6 of the Odisha sales tax from time to because of the new perception. This is the, if there is a public at large element is there, the principle of promissory estoppel will not apply. In a recent judgment, Supreme Court, considering more or less all the judgments, 2020, volume 2, SCC, page 57. Yes. No.
20 SCC 57.
তুমি সব তোমার জুনিয়র নিয়ে এসছো সব জাজমেন্ট না Here, my lord, I could the facts were more or less similar because here also there was an uncap, there was no cap that was said to be withdrawn. My lord would find paragraph 3, why the policy was paragraph 3 of the judgment, why the policy was introduced. the Kuch district had suffered an earthquake. Therefore, they wanted to invite more industries for which this particular scheme was floated. My lord, paragraph 5. The original writ petitioner set up new industrial units in Kuch districts. They made an investment Kutch, sorry. They made an investment in the plant and machinery of more than 20 crores. According to them, almost the entire duty was required to be paid in cash, the whole of which was refundable without any upper cap in terms of notification number so and so. It appears that the government announced in so much that was the withdrawal. That was the issue. Now, my lord, kindly see 21.2 paragraph.
Yes.
Not 20. It is observed in so and so, it is observed and held that the principle of promissory estoppel may be applicable against the government, but the determination of applicability of promissory estoppel against public authority government hinges upon the balance of equity or public interest. In case there is a supervening public interest, the government would be allowed to change its stand. It would then be able to withdraw from representation made by it, which include persons to take certain steps which may have gone adverse to the interest of such person on account of such withdrawal. Once public interest is accepted as a superior equity which can override individual equity, the aforesaid principle would be applicable even in cases where a period has been indicated for operation of the promise. 21.3 is basically the quotation of the judgment which I had relied upon. Now, my lord, the interpretation, which is 23.5. Case law and interpretation of fiscal statutes. I'll rely on 23.6, my lord, which is at page 94. In so and so, after considering various decisions on the interpretation of fiscal statutes, it is ultimately concluded that every taxing statute, including charging, computation, and exemption clauses, at the threshold stage would be interpreted strictly. Further, though in case of ambiguity in charging provisions, the benefit necessarily goes in favor of the assessee, but for an exemption notification or exemption clause, the benefit of ambiguity must be strictly interpreted in favor of the revenue state. And this is my sub. But I say, well, at 2006, a particular benefit or special package, whatever the nomenclature, was given to them. Well, certain benefits were extended. And the extension was always below, according to the fixed capital investment, which according to us, this is the cap, the 2 years that has been paid. Now, my lord, when the issue came up, we have interpreted saying that this 2000 scheme and 2004 scheme, although you are entitled to an IPA, it was in lieu of interest subsidy, which would have been much lower because it would have been 1 crore per year. That capping, to decap that particular capping on account of interest subsidy, this special package was extended. But it doesn't mean that the overall package, the scheme, has been diluted, overall dilution. And second point taken, if it is given, if particular benefit is given, this would create a situation, this would be somehow, I should say, public at large would suffer. But this has been my submission. But I say this is a reasonable interpretation by the authorities concerned. If there are two interpretations, and if then also, my lord, possibly will not interfere in a matter of this nature. And my lord, the judgment, I did not want to rely on the entire judgment of 2018, which was quoted in paragraph 23.6. It says, my lord, in a taxing where there has to be a tax has to be imposed, the assessee will get the benefit. But in an incentive scheme, if there is any ambiguity, it is the revenue that is going to get the benefit. And my lord, there is no vested right accrued in their favor. That is my submission.
Yes, Mr. Banerjee, short reply.
My lord, only
yes,
sir, it's
what?
My lord, we have a Xerox copy if you be position. Allow us to file that. My lord, but difficulty is, my lord,
what do you say there?
Well, reiteration of the scheme. Some
yes.
difficult, my junior, but if they not filed.
No question after hearing is over now. Yes, Mr. Banerjee.
But I will.
Just two or three things, and kindly also permit Mr. Sen if he wants to supplement.
Right.
First is it appears to be a now sort of case to use the 2004 financial cap.
Yes.
Otherwise, there is no financial cap. In page 147, we'll find when they sanction it, 10th August 2005, and when it shifted from the other place to Farakka, Murshidabad, 2nd March 2006, page 153 and 161, it clearly mentions the 2000 scheme, and it also says the subsidy is without financial cap.
Yes.
That's most important so far as that is concerned. Then we'll also find when the eligibility certificate is issued. That's at page 180. This is 2010 and 2011 and page 193. Then also it is without financial cap. So having continued the scheme and having paid under the scheme without financial cap, it is not possible now really turn the
clock back.
Yes, change the goalpost and say that no, sorry, you will now interpret in such a manner so as to impose the 2004. That is not what they would have done. So that's my first commission. Those pages Mr. Sen has already shown, page 147 and 153, page 161, page 180 and 193.
Yes.
That being the eligibility certificate itself, which spoke about the payment being made without financial cap. And pursuant to that payment has been made. First year, second year, half of third year has been made.
Yes.
Now, secondly, friend relied on this decision 1998 1 SCC and 2020 SCC page 57. 1998 1 SCC 572. There was really a question of having a policy. Here, there is no policy. The policy hasn't changed. It's a question of when you have to make out a case. Suppose this policy, they said, they came out and said, sorry, the 2000 is now, I'm doing away with it.
Yes.
That could have been a policy decision.
Right.
But here that is not the case. It is not that the policy has been done away with. What they try to do is to impose 2004, which is not applicable, financial cap 2004, to a scheme which was given as a special incentive scheme under 2000 itself. That's one of the eligibility criteria. So these cases which my learned friend relied upon to say there is no estoppel against statute and all that, the factually doesn't come in at all. Because either you, when you have a change of policy, the change of policy has to be here given, saying that why there's a change of policy. There's nothing. It's a question of the government, the WBID is really trying to interpret by saying that no, 2004 will apply. And that's one of the repeated case. And the overriding publication case has not been made out at all, insofar as their answer to our demand is. And they think 2.5 years you pay, you can't stop on the middle of paying half of that. And when the scheme itself says, we'll find at page 153 also, we'll find if commencement had started before, the eligibility would have been more. But since commencement started on 31st May 2007, the eligibility, there's a chart given there, which is 5 years, 2 months. And that's what we are entitled to at page 153. I submit that no different really cause has been made out as to why not. I'm sorry, with my limited ability here, I could assess if Mr. Sen wants to add, kindly permit him. I'm very grateful for permitting me virtually. Very good.
Pass my order now. The petitioners claim under an industrial promotion assistance, which is a special package of financial incentive given by the respondent authorities. It is submitted that under such scheme, under such package, incentives were disbursed in favor of the petitioner for 2 years, for a little more than 2 years. However, although the total tenure of this scheme was for 5 years and 2 months, the disbursals were stopped thereafter. Full stop. When the petitioners approached the respondent authorities for such disbursal, comma, our decision was taken at the level of the additional chief secretary, comma, Department of Industry, comma, Commerce and Enterprises of the government of West Bengal, comma, by virtue of which the non-disbursal of further amounts under the package was stood by, comma, primarily by borrowing certain provisions from a 2004 scheme, comma, which has no nexus with the special package granted to the petitioner. So next parallel, senior counsel appearing for the petitioner places reliance on the specific language of the additional package, comma, which is annexed at page 161 of the writ petition. First up, in the said communication from the Special Secretary of the Government of West Bengal, comma, Commerce and Industries Department, dated March 2, 2006, comma, the petitioner number 1, comma, it was recorded, comma, was had proposed to set up a cement manufacturing unit at Murshidabad in and around Farakka with an investment of rupees 100 crore. Full stop. The said proposal was examined and it was decided to extend the package as enumerated therein to the petitioner number 1 unit. Full stop. Next para. The said package contemplated industrial promotion assistance at the rate of 75% of the VAT and central sales tax within bracket CST paid in the year previous to the year for which IPA would be released without any financial cap by way of adjustment against VAT and CST liability of that year. Full stop. Next para. Among other provisions, comma, it was also stipulated that the unit will be entitled to all other subsidies as laid down in WBIS 2000, comma, except interest subsidy. Full stop. It is argued that the petitioners also obtained eligibility certificates. Full stop. That apart, comma, the sales tax authorities duly approved the claims now made by the petitioners. Full stop. By criticizing the order impugned herein, comma, learned senior counsel appearing for the petitioners argues that the entire premise of the same was erroneous. Full stop. Next para. The additional chief secretary, comma, it is argued, comma, primarily relied on the observations of the finance department purportedly dated December 28, 2018, comma, which was never served upon the petitioners. Full stop. As quoted in the impugned order, comma, the said report inter alia observed that in lieu of that the packages granted to the cement manufacturing units, including the petitioner number 1, were granted in lieu of interest subsidy under the relevant scheme. Full stop. Thereafter, reference has been made to the 2000 and the 2004 schemes, comma, which apparently contemplated a limit of rupees 100 lakh per year in respect of interest subsidy. Full stop. Next para. Learned senior counsel contends that such reliance on the 2000 and 2004 schemes was entirely erroneous, comma, since the petitioners do not fall within either. Full stop. Next para. The special package granted to the petitioners, comma, it is argued, comma, was not within the contemplation of either the 2000 or the 2004 schemes, comma, nor did it relate to interest subsidy, comma, as evident from the language of the said package itself. Full stop. It is reiterated that the package clearly mentioned that the unit would be entitled to all other subsidies to italic say, other subsidies as laid down in WBIS 2000 except interest subsidy. Full stop. Next para. That apart, comma, the impugned order also went on to find that the reference to within double inverted without any financial cap had to be read in the context of the cap of rupees 100 lakh per year in respect of interest subsidy, comma, which found place in the schemes in question, comma, particularly in para 20 within bracket small e within bracket small III of the WBIS 2004, comma, which is not applicable to the present case at all. Full stop. Next para. Thus, comma, it is argued that the impugned refusal of disbursal of the rest of the amount under the additional under the special package to the petitioners is required to be set aside, and the respondents directed to pay the rest of the amount. Full stop. Next para. Learned senior counsel, comma, while dealing with two judgments cited by the respondents, comma, also argues that the said judgments are not applicable in the present case, comma, since those relate to change in policy by the authorities, comma, which is not the case, not the present case. Full stop. In the instant matter, comma, it is argued, comma, the respondents started disbursing the subsidies under the relevant package to the petitioners and stopped midway. Full stop. Hence, comma, there is nothing to indicate that there was any change of policy as such by the respondents, comma, to attract the ratio laid down in the cited judgments. Full stop. Next para. Learned counsel appearing for the respondent authorities, comma, at the outset, comma, submits that the special package given to the petitioners has to be read in conjunction with the 2004 scheme, comma, particularly since the special package granted to the petitioners was on March 2, 2006, comma, when the 2004 scheme was already in force. Full stop. It is submitted that the letter and spirit of the 2004 scheme has to be borrowed for a proper interpretation of the special package issued to the petitioners. Full stop. Learned counsel places elaborately the judgment impugned, the order impugned herein. Full stop. It is contended that the observations of the additional chief secretary were justified. Full stop. By placing reliance on particular portions of the judgment of the order, comma, it is argued that the incentive schemes which were formulated to encourage capital investment in the manufacturing sector of the state, comma, which provided for subsidy to cover full 100% of fixed capital investment of the unit, comma, have to be read in proper perspective and should not be so interpreted as to override the general intention of the relevant incentive scheme, considering the socio-economic rationale behind such scheme. Full stop. The interpretation should not be contrary to the public purposes of the state, comma, so as to severely restrict its resources to provide multi-model citizen-centered services, including provision of public goods and other departmental needs for the common man. Full stop. Next para. By borrowing the refrain from the said order, comma, learned counsel for the respondents argues that the policy of a state always has to be read for the benefit of the public at large. Full stop. Next para. It is further argued that incentive schemes, comma, as opposed to taxing statutes, comma, have to be read in favor, interpreted in favor of the revenue granting authority stroke state. Full stop. Next para. It is argued by learned counsel for the respondents that the principle of promissory estoppel is not applicable to distribution of state largesse by way of subsidy schemes. Full stop. In such context, comma, learned counsel for the state places reliance on sales tax officer and another versus Shri Durga Oil Mills and another, reported at 1998, 1 SCC 572, and Union of India versus Union of India and another versus V full stop F full stop Limited and another, reported at 2020 within bracket 20 SCC 57. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires that the petitioners, comma, undisputedly, comma, claim under a special package, comma, which was given to the petitioners on March 2, 2006. Full stop. The petitioners have annexed due eligibility certificates and, comma, as such, comma, were obviously eligible for the scheme, for the package. Full stop. Next para. The said package, comma, in no uncertain terms, comma, specifies that the industrial promotion assistance would be at the rate of 75% of VAT and CST paid in the previous year to the year for which IPA would be released. Tapor italic say without any financial cap. Tapor normal by way of adjustment against VAT and CST liability of that year. Full stop. Next para. The emphasis, comma, supplied above, comma, clearly indicates that the package was meant to be without any financial cap. Full stop. The respondent authorities seek to restrict such expression to the subsequent clause that the financial cap referred to were in respect of adjustment against VAT and CST liability of that year. Full stop. Next para. Be that as it may, comma, since the IPA in question pertains exclusively to remission regarding VAT and CST paid in the previous year, comma, the context of the financial cap, comma, from which the petitioners were exempted, comma, has to be seen in proper perspective, comma, to mean to apply to the entire package itself. Full stop. Next para. The only restriction in the scheme was by way of clause Roman 2, which stipulates that the unit will be entitled to all other subsidies as laid down in WBIS 2000 except interest subsidy. Full stop. Next para. Hence, comma, it is clear that the WBIS 2000 is not applicable as a whole to the special package given to the petitioners, but was referred for the purpose of specifying the particular subsidies which were to be in terms of the 2000 scheme, comma, except, comma, of course, comma, interest subsidy. Full stop. Next para. Thus, comma, nothing in the 2000 scheme applies to the special package apart from the fact that the subsidies given to the petitioners were in terms of the subsidies as enumerated in the 2000 scheme, comma, except interest subsidy. Full stop. Insofar as the applicability of the 2004 scheme is concerned, comma, the argument of the respondent authorities is less proximate on such score than the 2000 scheme. Full stop. There is nothing in the special package given to the petitioners and annexed at page 161 of the writ petition, comma, which even cursorily refers to the 2004 scheme. Full stop. Taking a cue, CUE, from the arguments of the respondents, comma, the said package was given on March 2, 2006, but, comma, yet, comma, the 2004 scheme, comma, which was already in force then, comma, was never mentioned in any manner in the said package. Full stop. Hence, comma, the only conclusion which can be drawn is that the 2004 scheme was never meant to be applicable to the special package of the petitioners in any manner whatsoever. Full stop. Next para. There is no dispute as to eligibility of the petitioners. Full stop. The question which arises here is whether the respondent authorities can claim to have changed their policy vis-a-vis the petitioner and the entities covered by the special package only. Full stop. Next para. Nothing in the materials on record or from the arguments of the respondents indicate that there was a declared change of policy or an withdrawal of the special package given to the petitioner at any point of time. Full stop. Next para. Insofar as the judgments cited by the respondents are concerned, comma, the same are distinguishable from the facts of the present case on two very important scores. Full stop. In both the said judgments, comma, as mentioned in the judgments themselves, comma, the occasion of challenge was the declared change of policy by way of withdrawal stroke floating of previous or new policies. Full stop. Next para. The challenge, the entire gamut of challenge in both the said cases was such change of policy, comma, in which context, comma, the Supreme Court repeatedly reiterated that that the principle of promissory estoppel does not apply to respondent to the authorities or the state, comma, insofar as the same relates to policy decisions of the government or the respondent or the authorities. Full stop. Next para. The question of promissory estoppel is not relevant in the present case. Full stop. The doctrine sought to be invoked by the petitioners, in a sense, comma, is not promissory estoppel, but a notch, NOTCH, higher, that is estoppel substantially. Full stop. Next para. As opposed to promissory estoppel, comma, in case of a substantial estoppel, comma, an act has actually been done by the respondent authorities, comma, on the premise of which the petitioners have taken action and spent resources, comma, to the detriment of the petitioners in the event the respondent authorities resile from such position. Full stop. In the present case, comma, not only was a special package specifically granted to the petitioners on March 2, 2006, but the respondent authorities went on continuously acting on the same for more than 2 years by duly disbursing the subsidies in favor of the petitioners. Full stop. Next para. Nothing subsequently has been shown to indicate that the basis of the policy decisions of the state in that regard has been altered. Full stop. Next para. The present case is not a case where the state made a promise of giving a subsidy, but subsequently changed the policy decision, comma, thereby depriving prospective applicants for such subsidy from getting the subsidy. Full stop. The present case is one where an entity, comma, running its business on the specific premise of the promise given out by the state by way of a substantial package, comma, and was granted disbursals in terms of the said package for half of the period of the entire tenure of the said package. Full stop. The tenure was of 5 years and 2 months, and for more than 2 years, comma, the package was honored by the respondents. Full stop. Hence, comma, the respondents are squarely bound by the principle of, by the doctrine of estoppel in the present case, comma, which goes one shade higher than mere promissory estoppel. Full stop. Next para. That apart, comma, the argument of the respondents regarding the letter and spirit of the 2004 scheme being applicable is absurd. Full stop. The 2004 scheme has either to be is either to be applicable or not applicable in the present case. Full stop. The said scheme is not a landmark piece of legislation or juristic thought that its letter and spirit should be borrowed within the contemplation of the special package. Full stop. Next para. The 2004 scheme as well as the 2000 scheme operate in specific spheres. Full stop. The present petitioners did not at any point of time apply under any of the said schemes and were never disbursed any subsidy on such schemes. Full stop. The special package given to the petitioners was clear inasmuch as there would not be any financial cap by way of adjustment against VAT and CST liability of that year. Full stop. Next para. It was also mentioned that the entitlement of the petitioners was regarding all subsidies, comma, which were incidentally mentioned in the 2000 scheme as well, comma, except interest subsidy. Full stop. Hence, comma, the attempt of the respondent authorities to invoke the principles of the 2004 scheme and the cap stipulated therein, as well as the principles embodied in the 2000 scheme, comma, by itself, comma, is entirely malafide and arbitrary and designed to refuse the petitioner's disbursal of the legitimate claim under the balance amount covered by the scheme. Full stop. Next para. Hence, comma, there is no scope of giving a premium to the endeavor of the state. Full stop. Accordingly, WPA 9546 of 2019 is allowed, comma, thereby directing which respondent has to pay you. Yes, Mr. Chakravarti, tell me. Two.
Disbursement, we are appearing for respondent number 1 and 3.
1 and 3.
3. And WBIDC, we are not representing. Man.
WBIDC has to disburse.
Has to disburse. We are not representing
by directing the by directing the respondent authorities to ensure that the balance amount due to the petitioners, comma, to the tune of rupees 118, comma, 22, comma, 02, comma, 436, as the petitioners are entitled to under the special package in question, comma, be disbursed to the petitioners at the earliest, comma, positively within 3 months from date. Full stop. This much? Yes. Enough.
14th February, Malad, perhaps is set aside, Malad, if that is a formality, Malad.
Right.
14th February 2019, Malad, that's.
The order dated February 14, 2019 is, comma, thus, comma, set aside.
I'm very grateful.
Supplementary affidavit filed to be kept on record. Yes.
Was as mentioned in the supplementary affidavit.
Very well. 11822 যেখানে বললাম একটা ফিগার দিয়েছি একটু আগে, comma, in terms of the breakup given in the supplementary affidavit filed by the petitioners today. বাকিটা যাচ্ছে.
Some interest, Melody, your lordship.
Pardon?
If some interest, Melody.
No, let them pay this first.
Grateful. Extremely.
I was a bit hesitant to ask for that, but my junior.
No. That will be overkill, actually.
Thanks. I have given that enrollment number.
Yes, I have in my pocket.
I'm grateful.
Grateful.
Item 7.
Yes.
Item 7, I beg to appear to limit of service to.
Yeah. Please take the microphone a bit closer. Yes.
This is my lord. To my lord, in a short matter, my lord, there has been one notice issued by the my lord under the provisions of alleged provisions of Clinical Establishment Act,
yes,
wherein my lord the penalty was imposed and my lord and suspension order was given. Subsequent to that, my lord, I'll take your lordship to those annexures. Subsequent to that, my lord, another show cause notice was issued. Now, lordship will appreciate, my lord, under the provisions of Clinical Establishment Act, my lord, they can do so. But there is a clause wherein, my lord, the person who is tend to be prejudiced needs to be put on notice stating that these are the reasons for which we propose these actions, a show cause kind of a notice, wherein, my lord, I will get a reasonable opportunity to reply to those. Lordship, my lord, kindly takes up 2 annexures.
No, previously, we were already penalized, you said.
Yes, first I was penalized. Then the show cause notice was issued.
Oh, achha, for this, the show cause came later.
Yes.
Achha, let us see.
Lordship will kindly take the page 22 first. That is annexure P3.
Yes.
Here, my lord, is the show cause notice. The show cause notice, my lord, records in the second line of the first paragraph that there was an alleged inspection at around 12 p.m. on 7/11/2022. That is 7th November 2022. Now, my lord, wherein, my lord, it states, lordship will kindly, my lord, goes to the, my lord, the last paragraph. You are again directed to stop admission of new patient and all the services until a valid CE license is issued and existing patients are needed to be shifted to other healthcare facilities. Now, my lord, before that, I was given, my lord, 2-3 clauses that you are not functioning in accordance with the provisions laid down in the Clinical Establishment Act. You have to show cause.
What is that?
My lord, kindly takes up annexure P2 now. Lordship, my lord, the important thing is the 2 dates. Lordship, my lord, may I indicate in annexure P3, the date is 21st November 2022.
Yes.
And this notice, my lord, annexure P2 is alleged to be an order dated 14th November 2022. Lordship will find it, my lord, at the top. As per the direction taken in the hearing dated 14/11/2022.
Achha.
So, my lord,
all right.
This is an, my lord, alleged hearing. My lord, though my case is that I was not given an opportunity even to participate in this hearing. But, my lord, the fact remains is, my lord, I'm not taking your lordship because that will, my lord, again lead to some evidences and other things. My lord, prima facie from the face of the record, if your lordship kindly, my lord, sees.
The show cause was issued after the.
Yes. And the order itself is again, my lord, there is one column called grievances, wherein, my lord, 25 grievances has been recorded. And straight away, my lord, order. There is no finding and there is no specific indications also, my lord, how and when these things have been violated.
The petitioner, a clinical, the petitioner.
Well, petitioner number 2.
Yes.
Is Anarul Haq. He is, my lord, these.
The petitioner number 1 is a sole proprietorship of petitioner number 2 and is a clinical establishment under the Clinical Establishment Act, full stop, next para. The present challenge has been preferred by the petitioners against an order dated November 14, 2022, whereby the petitioner nursing home was, the petitioner number 1 nursing home was sealed and a penalty of rupees 14,81,760 was imposed on the nursing home. Full stop, next para. Learned Counsel challenges the said order primarily on 3 grounds. Full stop, first, the show cause notice dated November 21, 2022, annexed as annexed at page 22 of the writ petition within bracket annexure P3 bracket close was dated subsequent to the decision itself of sealing and imposing penalty on the petitioner, comma, which was dated November 14, 2022 within bracket annexure P2 at page 20 bracket close. Next para. Secondly, comma, the impugned order dated November 14, 2022 does not disclose any consideration of any material or even any assessment of the facts or material records, comma, before coming to the conclusion on as many as 25 grounds. Next para. Thirdly, comma, it transpires from the show cause notice that the specific grievances against the petitioner and or the allegations against the petitioners were not disclosed at all in the said show cause notice, comma, which vitiates the show cause notice itself, comma, since the petitioners did not have adequate opportunity or scope to address such allegations. Next para. In view of a strong prima facie case having been made out by the petitioners for setting aside the notice, comma, the writ petition is required to be heard on merits. Accordingly, the respondents shall file their affidavit in opposition within 2 weeks from date. Reply if any within 1 week. Thereafter, the matters shall be listed for hearing on September 25, 2023, fairly at the top of the list. There shall be stay of operation of the order, impugned order dated November 14, 2022, comma, whereby the petitioner number 1 nursing home was sealed and the penalty was imposed on the petitioner number 1, comma, there shall be stay till disposal of the writ petition.
Extremely grateful.
Thank you.
My lord, only one indulgence, if I may pray for, my lord, there has been certain subsequent event, though, my lord.
Affidavit is filed to be given to record.
Yes.
The petitioners will be at liberty to file a supplementary affidavit, comma, upon prior service of copy thereof on the respondents at the earliest, comma, on the next date of hearing. The opposition to be used by the respondents shall be composite in nature, comma, dealing with the allegations of the writ petition as well as the supplementary affidavit. Please do it immediately. Serve along with the writ petition.
Today I will file the supplementary.
Very good.
Okay.
Serve copies of the writ petition along with that.
Extremely grateful.
Next.
Item 8.
Yes.
May it please your lordship, I appear for the petitioner in this matter.
Yes. Service has been effected on this.
Lordship, I understand the respondent is appearing. Your Lordship, at the initial stages, I should point out a typographical error at page 5. Lordship, an order, the annexure P1 has been recorded as order dated 5/9/2022, whereas it should read as 10th March 2008. Lordship, this concerns the public provident fund account of one Mr. Jitendranath Basu. Your Lordship will understand his significance, that he was the bachelor owner of Prachi Cinema, and he was ultimately hounded out of his house. His last days were spent very, very miserably. In any event, your Lordship kindly comes to the first order. I shall take your Lordship through some of the orders. It starts from page 18. The petitioner here is the first, is the nominee of that public provident fund account. He has come up before your Lordship.
Next type is 18A.
Lordship, 18A is a clearer version of the order. Kindly takes it up.
Yes.
After completion of all formalities in accordance with law by the petitioner, if not already complied with the authorities of State Bank of India, they are directed to release the amount of money lying in State Bank of India Chodungi branch to the petitioner as registered nominee of the PPF account of late Jitendranath Basu in accordance with law within 4 weeks. Lordship, that was done. Subsequently, your Lordship, 2 persons claiming to be relatives of the erstwhile Jitendranath Basu filed a suit before this court. Lord, kindly comes to page 21.
Yes.
The claim is in the suit is in respect of the amount received by the first defendant, that is my client, from the Public Provident Fund of Jitendranath Bose, deceased. The plaintiffs claim to be the intestate heirs of Jitendranath Bose, who died a bachelor. The plaintiffs say that they are the son and daughter of a sister of the said deceased. Such position has been disputed by the first defendant. It appears that the first defendant has propounded a will of the said deceased, and the proceedings are pending before the Honorable City Civil Court at Calcutta. The present plaintiffs are among the several who are contesting the grant. The first defendant has fairly submitted that though the first defendant as nominee of the deceased has received the entire proceeds from the Public Provident Fund of the deceased to a sum in excess of rupees 19 lakhs, the first defendant has not appropriated the money. The first defendant points out that he had to institute a proceeding under Article 226 before this court to claim payment from the PPF authorities. According to the first defendant, the money is being held untouched, and the first defendant is agreeable to disburse the money to such persons who may ultimately be found entitled thereto. In view of such fair submission made on behalf of the first defendant is directed to make a fixed deposit of the entire amount received on account of PPF account of the deceased, together with any interest that may have accrued on the amount till date with a nationalized bank. Such fixed deposit should be made within a certain period. The original fixed deposit receipt will be held by the first defendant, and a copy thereof will be forwarded to the advocate representing the plaintiffs in the present suit. The disbursement of such money will not be made in favor of any person, including the first defendant and the plaintiffs, without appropriate person obtaining such orders as may be necessary for receiving such payment in accordance with law. Your Lordship, thereafter, Your Lordship would see that we have made the fixed deposit. My client has made the fixed deposit accordingly. That is, the fixed deposit certificate is at page 25. Lordship, thereafter, what has happened is the suit that was taken out by the plaintiffs was not contested. Lordship kindly sees the next order, page 27. None appears on behalf of the plaintiff. It appears from the report filed by the learned senior master and official referee that the plaint was lying defective since the institution of the suit, and the defect was removed only on the 7th of March 2014. However, the writ of summons could not be served since the advocate on record of the plaintiff has failed to take any steps with regard to the service of the writ of summons. The report also shows that the plaintiff has not taken any step for lodging the writ of summons within the time prescribed under the High Court original site rules. The Deputy Sheriff has filed a report on 20th March 2014. It shows that the plaintiff is not interested to proceed with the suit, and the suit is dismissed for non-prosecution.
Who else was the defendant with you, along with you? Who else was the defendant? You were the defendant number one. Who was the other person?
I think the bank was also.
So naturally, you had taken a fair stand. You said that I have deposited, so you did not contest, maybe.
Lordship, I did not contest, but they also did not.
Yes.
They did not do anything.
The suit lost its efficacy basically after this.
No, but the problem now is my client is aging. He is not in very good health. What he had come forward, we had given notices to the bank saying that since the suit has already been dismissed, kindly take steps to either include my son's name in that along with myself, or to disburse the money. Lordship, I shall take your Lordship straight away to the letter of the bank. The reply to the legal notice, Lordship, that is at page 32.
Yes.
In response to your letter dated 5, it's written to the advocate in record. In response to your letter dated 5/9/2022, when you requested bank to allow your client to operate and or withdraw the amount lying in the said fixed deposit account on the ground floor that the suit is dismissed, and the client has made a fixed deposit on the understanding before the Honorable High Court in CS number so-and-so that such deposit will be made and renewed until disposal of the suit. It is observed that the Honorable High Court video order dated 10/3/2008 in writ petition number so-and-so directed the bank to release the amount of money lying in SBI Chodungi branch to the petitioner, that is my client, as registered nominee of PPF account of late Jitendranath Basu in accordance with law, and the branch has settled the claim in accordance with the direction of the Honorable Court. It appears that Mr. Shomir Kumar De and Srimati Malarani Sen, Lordship, the plaintiffs in the next suit, which has now been dismissed, had filed civil suit number so-and-so against Porimal Chandra Dotto, that is my client, and the bank has also been a made party in the case. It is observed that on the perusal of order dated 24/12/2010 passed by the Honorable High Court, Justice Sanjeev Banerjee in civil suit being so-and-so and GA number so-and-so, that the first defendant had propounded a will of the deceased and the proceedings are pending before the City Civil Court at Calcutta. The present plaintiffs are among several who are contesting the grant. Mr. Porimal Dotto is directed to make a fixed deposit of the entire amount. They are merely repeating the order of the Honorable Court. It appears that the fixed deposit is made with our Calcutta University branch, but further, Honorable High Court held that the disbursement of such money will not be made in favor of any person, including the first defendant, that is Mr. Porimal Chandra Dotto and the plaintiffs, without appropriate persons obtaining such order as may be necessary for receiving such payment in accordance with law. It appears prima facie from the said order that the order has no relation with the disposal of the suit, and the specific order of the Honorable Court is required for payment operation of the said fixed deposit. Honorable High Court.
They are actually correct. The bank, from its own viewpoint, is correct. I mean, they don't want to take the Ms. Mitra, what is the, according to you, the person concerned died long back. In 2008, Justice Ghosh directed this disbursal. So you have been fair enough, and as recorded by Justice Banerjee also, and you put the amount in a particular account, which is. Now, as of today, there has been no claim. In law, the nominee is the receiving hands.
Yes.
I mean, there is nothing in law is supposed to
say that he is to receive the money. But what I am
nothing in law to also say, also to restrict you from using the money.
Lordship.
I mean, nominee is the receiving hands. After
there is no other claimant.
There is no other claimant.
Lordship.
So, although ideally there should have been a civil suit by somebody. I mean, if nobody chooses to file it, so why should you not be used?
Lordship, that is exactly my prayer.
Let me hear the bank of this. Yes, what do you say?
In the petition, it appears there was a will also. We don't know what is the fact of the will. Who has filed the what the probate has filed the.
You know about the will?
No one. It is stated here in the order.
Oh, I missed that out. I'm sorry.
I have mentioned it before.
Yes, you mentioned. I missed it out.
There is a will. It was being contested in the city civil.
Second paragraph of Honorable Justice Sanjeev Banerjee's order.
Right.
That is there. And the petitioner has no relations with the persons who kept the money.
Except that Jitendranath Basu remained in my residence till his last days, and then he went to Benin.
That does not give any title to a money.
According to you, what is the effect of the nomination? I mean, if I am a nominee,
to collect the money and
collect the money,
to give a discharge to the bank, but he is not entitled
to. Just to whom?
To the bank. Bank will get a proper discharge by paying the money to the nominee. And the nominee is answerable to all the years.
Bank is only an agent.
Here is nominee chapter is over, my lord, when PPF was paid.
Nominee chapter over, but if nobody claims the amount, what happens?
It goes to the bank.
Is there, what is happened to will?
Will is there, but if nothing is communicated,
I don't know.
Yes, there's nobody coming forward.
He was the party.
No, Ms. Mitra, only he's right. Your learned friend is right in saying that. You know that it was disclosed that yes, there was a will, a probate proceeding was pending before the City Civil Court.
Lordship, I can get information.
I think I'll direct you to do that. Besides, that is my line of thinking also.
Lordship, I shall try to get information on what has happened in the.
Yes, either by way of an information slip.
Lordship, but in the meantime, can I ask my learned friends to include the name of my son in the fixed deposit for the.
No, Ms. Mitra, I won't do that because unless if you have right, you get the entire lock, stock, barrel, the entire money. But your son does not come into the picture at all.
I'm just afraid that if something happens to me, the entire money goes to the bank. That was not the intention of the propounder.
With Mr. Shaha's expertise, it will take 2 or 3 days probably to get an information slip from there. I give you more time for that. I'll give you 1 or 2 weeks.
Lordship.
Take time. I'll fix it at the top. Just disclose that slip so that I can pass an order disbursing, directing the bank to disburse to you.
Well, one thing, Honorable Justice Sonjib's order is specifically stated that
legally,
money can be disbursed only they get an order from proper court.
But that's
the difficulty is twofold. I'm telling you, you are absolutely right on that. That is the impediment for which they are before court. Now, Justice Banerjee says the disbursement of such money will not be made in favor of any person, including the first general apprentice, without the appropriate person obtaining such order as may be necessary for receiving such payment in accordance with law. Now, this appropriate person has to mean a legal heir, one. Secondly, obtaining such order, he or she has to obtain an order.
Yes.
And thirdly, that order would be, he has to obtain an order which is necessary for receiving such payment. Apparently, before a civil court, one has to file a civil suit, get his or her rights canvassed, and get it thrashed there. If somebody does not come up, if nobody comes up,
then with a third person, he's
as nominee,
nominee third person. Nominee is here. Here is no nominee. Here he has opened a deposit account under order of the court. Nominee chapter is over.
How
chapter is over means he was the nominee.
In a PPF account, he was a nominee.
Nominee chapter over for the purpose because you are holding the money only by the direction of the bank. Otherwise, the nominee would hold it.
No. Yes.
You have no locus standi at all. The bank has nothing.
How does my learned say the nominee's role is over?
Bank has no locus standi here.
Nominee in the PPF accounts, nominee. They got the money. Under order of the Justice Honorable.
Your bank is holding the money because of the only reason that they chose your bank and put the money there.
No, yes. We are holding the money because the order of the Honorable Justice Sonji Banerjee. You
no,
keep the money
with
the bank.
Come to the order.
You keep the money with the bank.
Let us come to
in any nationalized bank, it's by chance that we have.
Let us come to that order. Please come to page 22 once. It was entirely their charity. Justice Banerjee's order.
Page 20.
Page 22, the second paragraph from the top. The first defendant. The first defendant has fairly submitted, that is them,
yes,
that though the first defendant as nominee has received the entire proceeds. So as nominee, the chapter ended there, not with keeping the money with you.
No. Yes.
Entire proceeds from the public. The first defendant has not appropriated the money and points out that he had to institute, etc. According to first defendant, the money is being held untouched and the first defendant is agreeable to disburse the money to such person. In view of such submission, fair submission, first defendant is directed to make a fixed deposit of the entire amount received on account of a PPF together with any interest that may have accrued on the amount till date with a nationalized bank. Now, these persons came up, they said, I'll deposit this particular bank. You cannot have any lien or any right on the
I am worried about it if somebody real claimant comes.
That is a real worry.
Yes.
That is
right. It is not my money, my lord.
I bring the information that
you are right.
My lord,
if there is nothing, then what happens?
Then happen. Today, possibly dismissed so many years and nobody here, it may be. But tomorrow, if somebody comes, but nowhere is order.
No, more than tomorrow, the choice now, option comes between S-sheet and them. Because this money, if nobody...
money will lie in the bank when the proper person will come, will take the money. Otherwise, they will take the money. They have no locus.
Either way, it has to be. Either they have a right to the money. If they don't have a right to the money, then nobody else has claimed for so many years. It will go to the state.
Ultimately.
So I prefer an individual to the state in the circumstances of the case. They were at least the nominee in the account. At least the person whose money it was.
Decided
settlement was for Jitendranath Basu. That person thought him to be fit to be a nominee.
Rather than some of his relatives.
The fairness is exemplary. I don't know about the son, but the father's conduct is exemplary. It was them that submitted before the court that I have not touched. They could have very well played with the money before the suit was filed.
Under law, nominee cannot appropriate the money.
Why
he can collect the money.
Why not? No, definitely.
That is settled law. Definitely. The nominee has only right to get a discharge.
Nominee right. What you are submitting is that receiving hands, you are not going one step further. You are confining yourself to the nominee. Nominee is the receiving hands. What happens after he receives?
Nothing. We have no control.
Bank in any event does not have any right.
Bank pay the money, nominee get discharged.
So I can
and that was over when in the order, pursuant to order of General Justice Pinaki Ghosh.
But pursuant
Justice Banerjee did not take it away from the nominee's hands, directed the money to remain in the bank. They have opened the account, it will remain in the bank. And after some time, if somebody comes up with a valid claim, it will be disbursed to him.
And with the appropriate order of the court.
An appropriate order of the court. If nobody comes, that was never contemplated in Justice Banerjee's order. That is where the grey area comes in.
So that is why we are thinking that we have no problem. If the court orders, they will pay the money. But tomorrow somebody comes, then what will happen?
They'll cite the court order. No, their money, their claim will be time burden.
Because they have contested it.
Their claim will not come to the bank also.
If anybody has so many years as per their will, it will be time barred. The money claim will be time barred now.
He is small, not a small amount of 42 lakhs today.
Depending on the person. I am dealing with crores from the morning. Please don't tell me, show me lakhs.
118.
The 118 crores and all these things, and you are citing 42 lakhs.
So that is a money.
How dare you? So I'm dealing in crores from the morning. Don't show money. Money has lost interest in me. Anyway, but 42 lakhs is quite an amount. You are right. So I'll direct them. I put in something in my order. Learned counsel for the petitioner submits that the petitioner was a nominee in the PPF account of one Jitendranath Basu within bracket since deceased bracket closed. First up, initially the petitioner was not being given a disbursal of the amount for which the petitioner had to approach court. First up, by virtue of an order dated March 10, 2008, a coordinate bench of this court, while disposing of WP number 27308 within bracket W of 2007, directed that the money be disbursed by the authorities in favor of the petitioner. First up, next para. Subsequently, a suit was filed by one Shamit Kumar De and another. First up, next para. In the said suit, the plaintiffs therein staked a claim as heirs of the deceased Jitendranath Basu to the amount lying in the Public Provident Fund. First up, in the said suit, with a order dated December 24, 2010, it was recorded that the present petitioner, who was the first defendant therein, had fairly submitted that although the first defendant stroke petitioner as nominee had received the entire proceeds from the PPF account, the petitioner was agreeable to not to appropriate the money. First up, next para. In view of such fair submission, it was recorded, the first defendant stroke petitioner was directed to make a fixed deposit of the entire amount received on account of the PPF account of the deceased, together with interest that they may have accrued on the amount till date, with a nationalized bank. First up, pursuant thereto, the petitioner has deposited the amount with the respondent bank, that is the State Bank of India, where it is lying now. First up, the tricky point arises in an observation made by the learned single judge while passing the order dated December 24, 2010, to the effect that the disbursement of such money will not be made in favor of any person, including the first defendant and the plaintiffs therein, without the appropriate person obtaining such order as may be necessary for receiving such payment in accordance with law. First up, next para. The suit, however, was subsequently dismissed for non-prosecution and has not been revived till date as per the knowledge of the parties herein. First up, next para. There was another observation in the order dated December 24, 2010, which also somewhat complicates issues. First up, it was observed by the learned single judge, that it appeared that the first defendant stroke petitioner had propounded a will of the said deceased, and the proceedings are pending before the City Civil Court at Calcutta. First up, the plaintiffs therein were among the several who were contesting the grant. What is your instruction on this? The probate, because you are the propounder.
I'm told that it's still going on, either or it may have been dismissed by now. They were not.
মক্কেলই তো ফাইল করেছে
এই তো উইলটা আমরাই ফাইল
pending আছে
সরি
That is why we will have to wait for that. He's right. Who's the next para? Learned counsel for the petitioner submits that in view of no rival claim till date, comma, the amount be disbursed in favor of the petitioner and or the petitioner's son be named as an you want to be added as a co-holder of the account.
Lordship, that would at least be
a joint holder of the account.
The other interesting point, I've just now been told that my client is also the executor of the will of Jitendranath Basu.
Yes,
so
because if you choose not to, they have a point there. If you choose not to get it.
No, I will definitely, I have put it on.
Very well. Next parallel, counsel for the bank contends that although the bank does not have any personal interest in the issue, comma, for the sake of justice, comma, the observation of the learned single judge in the order dated December 24, 2010, passed in CS number 208 of 2010, ought to be honored. Full stop, it is submitted that till date, comma, there is nothing on record to show that any appropriate person has obtained such order as necessary for receiving the amount in accordance with law. Full stop, that apart, comma, it is pointed out by learned counsel for the bank that the probate proceeding was admittedly pending at the relevant juncture at the behest of the first defendant stroke petitioner, comma,
still
the
pending.
outcome of which is also required to be
Still pending. He's a petitioner.
awaited. We don't know that.
He's saying
Awaited. Full stop. There is nothing on record to say that. Still awaited. Full stop. Next para. Accordingly, unless the petitioner produces any document before this court to apprise the court as to the current status of the probate proceeding, comma, the present writ petition cannot be decided, comma, since there has been no rival claim till date regarding the amount lying with the respondent bank in lieu of the amount disbursed pursuant to the PPF account of the deceased Jitendranath Basu. Full stop. Next para. As such, comma, the petitioner is directed to inform the court in writing, comma, either by way of an information slip or by way of a letter written by the learned advocate conducting the case in the probate court, comma, as to the current status of the probate proceeding. On the next returnable date, full stop, such the matter shall next be listed on, should I give you 1 week or
2 weeks?
Accordingly, the matter shall be listed next on September 14, 2023, fairly at the top of the list. Full stop. The written communication to be submitted by the petitioner. Now, a copy of the written communication to be submitted by the petitioner shall also be given in advance to the learned advocate appearing for the bank. The question which will arise is, if they choose not to proceed with the probate proceeding, suppose they choose, they have a right to choose, then what happens? Can we compel them?
no, it did not right, but I am
That is-
saying
that
what
is
is
the-
the locus to get the money? That is my question is.
Yes, you have a point there. Even as a nominee, whether they have a right to appropriate the amount.
Who has?
But
then who
It is
does?
central of Madam Supreme Court.
Yes.
I'll direct
Nobody
it to
can
be
appropriate.
I'll direct it to be paid to the judge's benevolent fund, which will be opened from this case onwards.
Only thing is that the gentleman deceased gentleman reposed a lot of faith on my client is that he's
So
not
you
only
have honored that faith.
not only is he a nominee, he's also been made the executor of the will instead of his grandniece and the other nephews and nieces.
So he has justified the trust, but depends on what he does ultimately in the probate proceeding. If
In
he
fact,
keeps
he
that
had-
pending, then
In fact, the desire of the deceased was that my client and some others run the cinema hall, which they have not been able to do because of takeover by a certain relative.
why did you take in the meantime? You should have done something. This was an order of 2011, so we are now in 2023.
No, because
12 years, a decade.
he has aged now. He's not keeping good health.
What was he doing for these 10 years? I mean, he was less than 60 then.
Yes.
Less than 60 then. He could have taken a probate and distributed the property
He is the
among the heirs.
probate court. He is the petitioner. the lawyer, and other the contesting. That is they are saying. He's saying. He's the petitioner.
No, he's the
being executed.
He's the executor, and thus he has filed.
He means the petitioner.
Lordship.
Petitioner or Mr. Shah?
Yes.
Mr.
He's pointing to me. Yes.
That I told. That he is a petitioner. আপনি তো প্রপোর্ট করে প্রপোর্টের জন্য অ্যাপ্লাই করেছেন অন বিহাফ
he did not apply.
না আপনি অ্যাডভোকেট তো
No, we couldn't.
No, he was meaning Mr. Shah actually. I was right on that. Yes.
Good.
Item 9.
No.
Meet, please, Your Lordship.
Yes, Ms. Mukherjee. What is that?
Lordship, the writ petitioners before Your Lordship.
Yes.
They were. Your Lordship, may I go back? This has a bit of a background.
Right.
Your Lordship, the writ petitioners were to be appointed. They had applied for being appointed as apprentices in the railways, for the railway in Chittaranjan locomotives. Well, Lordship, what happened at that time when initially the advertisement was for only those persons who have got a vocational training certificate. Now, subsequently, Your Lordship, a list was drawn up. After that, Your Lordship, suddenly a new list was drawn up where the vocational certificate was also provisional vocational certificate candidates were brought into the next list. And so by those who had a vocational certificate, they went down into the list, in the serial. So they filed a writ petition before this Honorable Court. Lordship, that writ petition was heard, and this Honorable Court held that no. The criteria which was existing at the time of advertising, that criteria will prevail. And so those who have got a certificate, a vocational certificate, they are the ones who will come in who will be given apprenticeship, and the others will not. So, Lordship, the others, because their names are already in the list, they filed an appeal against that order. In the appeal, Your Lordship, this court was, in the appeal court, Your Lordship, that matter was disposed of with a direction, Your Lordship, that those who had already had the vocational certificate, they had already completed practically 8 months of their training. So it was directed that their training will be completed and the remaining will be given the second chance. That was the order. The remaining their training will commence after the first batch of training is completed. Lordship, when the second batch of training was initiated, it is found that those who have been called for training, there has been a pick and choose. Only few people have been called for the training and some have not. So those who have not been called for training are before Your Lordship. May I take Your Lordship through now, Your Lordship, knowing this is in the just matter, may I take Your Lordship to the various orders that were passed?
Page 90.
Yeah. Lordship, page 94. Page 92, Your Lordship, where the division bench order commences.
Yes.
The controversy lies in a narrow campus in the factual background that initially notice was issued for the engagement of act apprentices in Chittaranjan locomotives with the opening date of 24/7/15 and closing date 24/8/15. The eligibility conditions were prescribed in clause 6 of the said
Rest of you,
notice.
please take your seats. Yes. Please continue.
Was prescribed and clause 6 of the said notice, and in terms thereof, the candidates must pass out IIT examination, NCVT only, and they must have the certificate in notified trades for applying under point 1A of the said notification. Clause 12 of the notice requires the candidates to submit ITI certificate if applied for in the relevant trade affiliated to NCVT. Some of the candidates were not having the final certificates, but were having only the mark sheet of the ITI examination, had approached the writ court by filing a writ petition with the prayer that the requirement of submitting the certificate is not mandatory. The learned single judge by order dated 5/6/17 had dismissed the writ petition with the conclusion that submission of certificate was mandatory and the provisional certificate will not do. It appears that thereafter the respondent authorities had issued the internal communication stating that candidates who submitted their original mark sheet certificate from their respective institute fulfilled the minimum technical qualifications. And on that basis, the second select list was prepared, which was subject matter of challenge before the learned single judge in the present petition. The learned single judge has reached to the conclusion that in view of the earlier order passed in the first list, the second list could not be sustained and accordingly quashed it. Learned counsel for the private respondents has submitted that in pursuance to the order of this court, private respondents have already been sent for apprenticeship training and they have almost completed 80% of their training and only 40 days remaining. And as per their understanding, after their completion of the training, the applicant's case for training will also be considered. Learned counsel for the railways
these people, all of these people then who now participate, they had their IKI certificates.
There were one who had the NCVT and the others who did not have who had a pro NCVT, a provisional. So, Your Lordship, the court held initially the division single bench held that the pro NCVT are not eligible.
Not eligible, right?
Then, Your Lordship, they filed an appeal.
Yes, yes.
And this is their appeal.
Right.
In this, Your Lordship, the railways Council for Railways has also fairly stated before this court that after completion of the training of the private respondents, the railway authorities will duly consider the issue of sending the appellants on training in accordance with law. Learned counsel for the appellant agrees on the above stand of the learned counsel for the railways. Hence, we take the stand of the railway authorities and dispose of the appeal accordingly.
So all these people who had had training for some time or did not, all of them had
those who had
activities.
Lordship, those who had an NCVT certificate.
The persons with the provisional NCVTs had been screened out by the single judge.
No, yes, Your Lordship. Previous, Your Lordship, there was previously the list was only of those with the NCVT.
Right.
The second list came out, which was for the pro NCVT.
Pro NCVT also, yes.
Then, Your Lordship, when the NCVT came before this honorable court, the court held that no, the pro NCVT have no right.
Right. Yes.
Then the pro NCVT came before the appeal court. Yes. And this is an application made by those who have a pro NCVT. And in this application, Lordship, the railways has conceded that after completing of the training of the NCVTs, the pro NCVTs will be given training.
Pro NCVTs were never given that liberty.
Lordship, this is the order of the pro NCVT.
This order says Railways has also fairly stated that after completion of the training of the private respondents, railway authorities will duly consider the issue of sending the appellants on training in the appellants were the NCVTs.
No, Lordship, the appellants were the pro NCVTs. The appellants before Your Lordship were the pro NCVTs.
No, before just this division means those
before the division bench.
But they were the pro NCVT.
They were the pro NCVT. Yes. Because when this appeal was filed, Your Lordship, there was a stay. Initial stay. And that is why after completing 80% of their training, those who had the NCVT, they could not.
So virtually the railway authorities allowed the
pro NCVT. That already we will give them.
Among them also there has
now amongst the pro NCVT, Your Lordship, they have picked and chosen. They have taken a few and they have not taken.
You are the few who have been left out.
Who have been. Lordship, very interesting, Your Lordship, what they have done, I must be honest with Your Lordship. What they have done is, they have only taken those who were the appellants in this case. They have not extended it to all the others who had a pro NCVT, who were not the appellants before this court. Lordship, by going through the records, this is what I find. What they have done is, they have taken all those who were appellants.
Least resistance path.
So this is the
yes. How do you distinguish between the two? All the pro NCVTs have to come in there.
Oh, my lord, I would like to draw your lordship's kind attention at page 94 of the order, where it has been specifically stated that the I'm reading this paragraph, my lord.
Please, Mukherjee, please take your seat. I'll hear him and come back to you in reply.
The railway authorities are expected to consider the case of the appellants, my lord.
Achha, that's
not of the
That's why.
It's a judgment in personam, my lord.
So this this becomes Article 14 violation also. Now, it will be an independent order of this court now. They are similarly placed.
My lord, the fact I would like to draw your lord's attention to the entire fact. In the first instance, my lord, the petition
pro NCVTs have been allowed. Some of them have been chosen by you. Only the appellants. You initially took a stand that no, pro NCVTs would not be allowed. Only the NCVTs would be allowed. That stand was upheld by the single judge.
My lord.
Appeal was preferred by the Yes, yes.
Meanwhile, my lord.
Yes.
The panel of 128 ITI past candidate was published on 2nd of November 2016, my lord.
All right.
On 8th July 2017, Vigilance Department had raised objection on rejection of the provisional NCVT candidates and proposed inclusion of their names in the selected list of apprentices. This administration thereafter ordered re-scrutiny of the apprentices.
Which portion are you reading? Page?
And as a result of
which page are you reading?
My lord.
What are you reading?
My lord, the instruction, my lord.
Your instruction?
Yes.
Achha. All right. I thought you were following.
No, my lord. As a result of re-scrutiny of the provisionally NCVT candidates were included in the panel, and a fresh list was published on 14th of February 2018. In the revised list, due to escalation of cutoff marks, 41 candidates who were in the earlier list were excluded, my lord. These 41 candidates filed the writ petition bearing number 5143 of 2018. That writ petition was turned down by the Honorable Single Bench. Thereafter, my lord, some of the candidates, not all of the pro-NCVT candidates, challenged the order of the single judge, and the order of the appeal is a specific direction was given to us to consider the candidature of the respondents, my lord. And accordingly, we have complied with the order reflected in page 96, my lord.
And you also, your concession also said that you will duly consider the issue of sending the appellants on training.
My lord.
So even after the disposal of the appeal, according to you, the pro-NCVTs themselves did not get any opportunity to participate as a blanket proposition. And the order of the single judge remains. The learned single judge said that pro-NCVTs won't be permitted. Some of the pro-NCVTs took out an appeal. They were only permitted. You only considered to them being considered, and they were only to be considered, those appellants. But this appeal does not set aside the single judge's order.
Yes, my lord.
You don't understand what I'm saying.
Yes,
I could not make myself clear. I'm telling you this. The initial order of the learned single judge was, I'm referring to provisional NCVTs as pro-NCVT, as Ms. Mukherjee pointed out, referred to. Now, pro-NCVTs were totally excluded initially. Learned single judge affirmed that, said no, pro-NCVTs won't come in. Only the NCVTs. An appeal was preferred by the pro-NCVTs.
Not by all the pro-NCVTs.
No, only those pro-NCVTs who had participated, who had filed that in the
appeal was preferred by the candidates
some of the
second list, my lord.
Second list.
Second list, my lord, which was curtailed down by the single judge.
And these people are from the first list?
These people are from the first list, my lord.
The appellate court did not deal with the second list, first list, this dispute?
No, my lord.
Achha, please come to page 93 once. Second last paragraph. It refers to the learned single judge having reached a conclusion that in view of the earlier order passed in the first list, the single judge decision was on the first list.
First list, my lord.
Achha, at that point of time, only the first list was there.
First list was there. No, my lord. The second list was also adjudicated in the writ petition being WP number 4154.
Second list was adjudicated. Achha, say that was also adjudicated.
Because the second
what
list
is this reference? In view of the earlier order passed in the first list, what was that order? Page 93, second last paragraph refers to an earlier order passed regarding the first list. Where is that? What was that?
The earlier order, my lord, the first list was published on 2nd of November 2016. After publication of the first list, Vigilance Department raised.
When was the second list published?
Thereafter, on the recommendation of the Vigilance Department, second list was published.
When?
Second list published on 8th of July 2017, my lord.
2017?
2017. And because of the inclusion of the provisional NCVT candidates, 41 candidates have been excluded who were in the first list, my lord. Those 41 candidates came to the High Court for filing writ petition, my lord.
May I clarify, your lordship?
No, it's referred to in the learned single judge's order. I'm looking into that. Please come to page 70 and read it out. In the meantime, I'll also.
17.
70.
Oh, 70. First single judge.
Please read out the single judge's order. It's there. In the first instance, some of the pro-NCVTs had approached the court. That was the reported judgment. It was dismissed. Subsequently, the second writ petition was filed.
Lordship, despite the first list having been set aside by the Honorable
second
Court,
list was
the
published.
second list was published, in which again the pro-NCVT were taken into consideration.
Yes.
So that was challenged.
That was what
That
prompted.
was challenged.
Yes. So,
It is writ.
Right. So then the learned single judge set aside that also.
Lordship.
And it was also on the ground that in such circumstances means that that was not followed. The Jagdish Dwivedi was not followed. Therefore, very well. So it came up to the division bench. What the division bench did was merely that some of the provisions had preferred this appeal before the division bench.
Yes.
Pro-NCVTs. Now they have been permitted by virtue of this division bench order.
That is their
That is their case. Now you are other pro-NCVTs. You are never allowed.
Lordship, we are the pro-NCVTs.
Yes.
We were not allowed at the first instance.
At the very first
At
instance,
the first
no.
instance, we were not allowed. When we came to the
Koshak
second
also
writ
not
petition,
allowed.
he did not allow. He
Yes.
did not allow the pro-NCVTs.
Yes.
The pro-NCVTs came into appeal. When they came into appeal, your lordship, the division.
Some of the pro-NCVTs.
Yes.
That is a relevant factor here.
Yes, your
according to
lordship.
their
Some of the pro-NCVTs, they
yes.
came before this honorable
Yes.
court in appeal. And in appeal, your lordship, there was a submission made by the railways that all right, after we complete with the NCVTs, we will give the pro-NCVTs a chance. And of course, the court, because they were there before the court held that already you will give the appellants a chance.
As it appears
And
from the
your
order,
lordship-
Ms. Mukherjee, that is not the case. Learned Counsel for the Railways fairly stated that after completion of the training of the private respondents, the railway
The
authority.
private respondents are the NCVT candidates.
NCVTs.
Yes.
After that, the railway authorities will duly consider the issue of sending the appellants on training in accordance, not the pro-NCVTs in general,
Lordship-
only the appellants. And that was considered, and the court also directed
Lordship,
to
but
consider
what-
the case
but
of the appellants.
If I may make one submission for you, Lordship. What was there before the court? The issue before the court was whether the learned court has held that the pro-NCVTs are not eligible.
That issue was never decided, Ms. Mukherjee.
Lordship, that was not decided.
The
But your
division bench
lordship,
did not decide.
if we look at this judgment, your lordship knows, right, that when judgments are passed, your lordship, a judgment in rem and a judgment in personam. Lordship, a judgment in personam becomes a judgment in personam if the issue is answered, the larger issue is answered, and after it hasn't been answered, it has been determined to make an exception in respect of those people only. Since the larger issue was not answered, your lordship, the larger issue remains open. And your lordship, when the larger issue remains open, they cannot bring it into the confinement of this, making it a judgment in rem, in persona. Your lordship, a judgment in persona, your lordship, has to go into the larger issue. In my humble submission, lordship, I've got certain judgments I'll place before your lordship.
Yes.
That a judgment in rem, your lordship, and a judgment in persona. Similarly placed persons, your lordship, cannot be just denied the right.
Even if it is a judgment in personam, you say that Article 14 is there.
Yes. Lordship, because the court has actually not decided the larger issue about the pro-VCs, pro-NCVTs and NCVTs.
Yes.
The court has left that question open. That means, your lordship,
does not remain open because the single judge's order then revised.
Yes.
Which says you don't have a right.
So, your lordship, if an exception is carved out, the court does not say I'm carving out an exception. A blanket consideration, your lordship. And at that time, your lordship, there was no one there before the court to say that there are others. Lordship, may I place one judgment before your lordship?
Yes, you will be entitled to reply to this judgment if you want. Yes. Only the judgment is Mr. Mukherjee because
yes, your lordship. I'm giving you a copy. I'm giving my learned friend a copy, your lordship. This is a judgment, your lordship, of 2008 Supreme Court cases. And your lordship, this is a judgment of Madras High Court. I'll then come to the Supreme Court judgment after this. Lordship, will kindly come to paragraph 21.
Yes.
Lordship, this is a case, your lordship, where the petitioner was appointed as a junior assistant. And thereafter, your lordship, the promotions were held and there was a... Lordship, the promotions were slated and in that she was not included. So she has come before this court and your lordship, the question was taken up whether her seniority can be given effect to after the...
Para 21 less than the proposal.
Yes. So lordship, here he further added that when a decision of the court or tribunal is rendered with regard to the applicability of a statutory provisions to a class of persons, the effect of the panels prepared to the post of assistance, the said decision is equally applicable to all persons similarly placed and there is no need to file a separate writ petition. Lordship, in that case also the same thing had happened. A class had been formed, created, and in that class, your lordship, they came before the court. She did not. A few of them did not. So they say when a class is created, not everybody does not have to file a writ petition. According to the counsel for the petitioner, decision rendered on the subject matter of preparation of panels and its effect on the members of service has attained finality. And therefore, the decision of the tribunal made in the case of Mr. Amoruddin is a judgment in rem. And the rejection of the petitioner's case, stating that the judgment would be applicable only to the said individual, is erroneous. In this case, your lordship, now this is the proposal before the court. And then your lordship will kindly come to to paragraph 28. 27, your lordship.
27 is the entire mankind thing.
Lordship, that is very important. 27, 28, 29. Lordship, exactly what I'm submitting.
Historically, in them, everybody knows that.
Lordship,
law students know that.
All. Lordship, then come to page 29, paragraph 28.
Yes.
The judgment in rem signified as judgments which are good against all mankind and judgments in personam signified the judgments which are good only against the individuals who are party to them and their previous. The point adjudicated upon in a judgment in rem is always as a status of the res and the conclusive against the world as to that status, whereas a judgment in personam, the point, whatever it may be, which is adjudicated upon, not being as to the status of the rest, is conclusive only between the parties or the previous. Your lordship, here, the status was pro-VC and NCVT. And that, your lordship, was not decided. Your lordship, what the court did, all right, you are before me, I'm granting it.
If that is not decided, what is the effect?
Lordship,
how can it be a judgment in rem on that point at all?
Lordship, that is why it becomes a judgment in rem.
Because can it be a judgment in rem for what is not decided?
No, Lordship, it becomes a judgment in what has been decided.
What has been decided?
Lordship, in this court, Lordship, by appeal court, your Lordship granted the pro-NCVTs.
Because they agreed.
Because,
particular persons, some of the pro-NCVTs.
But Your Lordship, that was not on any merit or anything like that.
Exactly, it was not on merit.
They only agreed because they filed a writ petition.
True.
So, Lordship,
what the division bench did was no adjudication on merits at all.
Yes, Your Lordship.
So, if there is no adjudication on merits by the division bench, the findings of the single judge remain rather.
Lordship, where this finding of the single bench is there, if that would have remained, if it had remained in the conscience of the division bench, then Your Lordship, the division bench would have not allowed it.
Some of the
Lordship,
people, because they allowed.
what was there before the division bench, Your Lordship? It was before the division bench, Your Lordship, that there was a list, the previous list, which only for the pro-NCVTs, that was struck down.
Yes.
Then, Your Lordship, before the division bench was also a list which was only for the NCVTs,
right,
which was allowed. And Your Lordship, the division bench actually went into the struck down list and gave a right to to the appellants on that struck off list, without going into the question why. So, Your Lordship, if the rights of some of the persons in that list is revived, then it would be a judgment in rem, because Your Lordship, that entire list remains. The court has not gone into the question saying that, all right, just because you are before me, I'm doing gratification towards you. That was not the case of the court, Your Lordship. The court was faced with two lists, the pro-NCVT list and the NCVT list.
Right.
And the court has allowed the pro-NCVT list in this writ petition because they were before the court. And that is why, Your Lordship, it has been held in this paragraph 21, which says, Your Lordship, which has been argued before the court below, that a decision of the tribunal is rendered with regard to applicability of statutory provisions to a class of persons. The effect of the panels prepared to the post of assistance, the decision is equally applicable to all persons placed, and there is no need to file a separate writ petition. Lordship, we are all similarly placed persons. There was no necessity for all of us to come before this honorable court or to file a writ to get our right crystallized. Lordship will kindly then come to the Supreme Court judgment of 2015. I'll place it before Your Lordship.
Yes. Yes.
Lordship, may I first set out the head notes? Service law relief, parity, exceptions to delay latches, acquiescence, effect of entitlement to benefit of judgment in rem with intention to benefit all similarly situated persons, irrespective of whether they approach the court or not.
You can come directly to the longer headlines.
Lordship.
Please come to the next page.
Lordship will come to paragraph 22.
No, you can come to the next page, very next page. 348, held. You can start from the beginning of the long head notes.
Held. The moot question that requires determination is as to whether the approach of the tribunal and the High Court was correct in extending the benefit of earlier judgment of the tribunal, which attained finality as it was affirmed till the Supreme Court. The legal principles that can be culled out from the judgment cited by both the appellants as well as the respondents can be summed up as follows. The normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution. This principle needs to be applied in service matters more emphatically as the service jurisprudence evolved by the Supreme Court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently. However, this principle is subject to well-recognized exceptions in the form of latches and delays, as well as acquiescence. Those persons who did not challenge the wrongful action in their cases and acquiesced to the same and woke up after a long delay only because of the reason that their counterparts who had approached the court earlier in time succeeded in their efforts, then such employees cannot claim that the benefit of judgment would be treated as fence sitters and latches and delays, and or acquiescence would be a valid ground to dismiss their claim. Lordship, delay is an exception which has been, and I'll
not only delay, fence sitting.
Lordship, fence
As in
sitting
your
and
case, as in
Lordship, I'll show your Lordship whether there is fence sitting or not. I'll come to that, your Lordship.
When did you file the writ petition?
Lordship, I filed the writ petition.
Justice Srivastava's division bench held that in March 2022. You came 1 year after.
Lordship, I did, because only after this they published the list. Okay. We were not supposed to know that they will not consider. The moment they published the list, I have come before this court. However, this exception may not apply in those cases where the judgment pronounced by the court was judgment in rem with intention to give benefit to all similarly situated persons, whether they approach the court or not. With such a pronouncement, the obligation is cast upon the authorities to itself extend the benefit thereof to all similarly situated persons. Such a situation can occur when the subject matter of the decision touches upon the policy matters, like scheme of regularization and the like. On the other hand, if the judgment of the court was in personam, holding that benefit of the judgment shall accrue to the parties before the court, and such intention is stated expressly in the judgment, or it can be impliedly found from the tenor and language of the judgment, those who want to get the benefit of that judgment extended to them shall have to satisfy that their petition does not suffer from delay or latches.
Right.
Then your Lordship will kindly come to paragraph 22.
Is the crux of 22 has been set out there, actually.
Lordship. The legal principle emerged from reading of the aforesaid judgment cited by both the appellants can be summed as follows. The normal rule is that when a particular set of employees is given relief by the court, all other incidentally situated persons need to be treated alike by extending that benefit.
Ms. Mukherjee, this has been paraphrased.
Yes.
Right,
Lordship, kindly consider this.
Yes.
Jagdish matter was filed by a few people.
Right.
Despite that matter having been filed by just a few people, the railway authorities published a second list in favor of all the pro-NCVTs. When Jagdish was a matter filed by only one person, or maybe a few, they did not limit it to only those writ petitioners. They published the second list, making it applicable to all, including me. So, Your Lordship, when a few went into appeal, it was not a case that railways would again confine themselves to that. When in case of Jagdish, Your Lordship, they have acted as a judgment, as an order in rem. They have taken in everybody, considered everybody. Lordship, railways is an authority. Lordship, and what are we asking for? We are not asking for employment. These are just apprentices. Your Lordship, apprentices do not get an employment in the railways. All they do is they get a training, and by virtue of that training, they get a chance of employment at other places.
Ms. Mukherjee, this would be a very good case before this court if it was the first instance. Undoubtedly, because I personally am of the opinion from seeing the facts of this case, yes, non-NCVTs also, I mean, it is not due to any fault of theirs. They have provisional certificates, that doesn't mean they are at fault. True. But I am not the first authority taking up. What is striking me here is Justice Bosak in the first instance, Jagdish Divedi's case was there. I mean, it was not accepted. Pro-NCVT. Justice Bosak took the same view, at which point of time the second list had already come. Justice Bosak had adjudicated on that, saying that whatever happened in the first list has to happen in the second list. So that view remained till it was filed in appeal, challenged in appeal. Challenge in appeal was preferred by some of the people. Otherwise, you are very correct in saying that, yes, some of the people filed, but the ratio was decided that has to apply to all. But the difficulty, Ms. Mukherjee, arises when the division bench decides the matter. All the findings of the division bench everything is on learned counsel for the railways has also fairly stated such and such. What have they stated? Not that pro-NCVTs has to be. They say after completion of the training of the private respondents, that was the consideration. They have started training. The railway authorities will duly consider the issue of sending the appellants on training in accordance with law. First. Second is that learned counsel for the appellants agreed to that. And then we take the stand of the railway authorities. That was the finding of the division bench. that it takes the stand of the railway authorities and dispose of the appeal accordingly. So there was no adjudication setting aside Justice Bosak's judgment at all. Believe me, if there was even one line of ratio on this, that yes, that order does not stand in view of this submission of the railway, that would suffice.
May I make one, sir?
But that is not there.
Lordship,
I don't get the handle.
Lordship will allow me to come back. I'll tell your Lordship why. I'll bring Jagdish's order before your Lordship. Lordship will kindly see what happened before the court. There was
Justice
the order.
Bosak's order is the last order which had some ratio, which is before me, which goes against you.
Lordship, and Jagdish's order is not annexed. I have to place that.
Suppose Jagdish has both, it's ambivalent.
Lordship.
Even after that, Justice Bosak interpreted
Lordship.
it and said that Jagdish principle applies here. What is the principle? That they did not succeed, NCVTs did not succeed. So I'll also, in the second list also, the same principle has to be followed. And Jagdish was interpreted by Justice Bosak, which is the last ratio on this subject.
Lordship, and your Lordship, and when a few went up to court, the railways conceded. Suppose all of them were in court.
Railway conceded because in the second list, they had included the provisions.
Lordship, we were included in the second list.
Exactly.
We were included in the second list, your Lordship. It is not that we were not included, your Lordship. We are not before your Lordship because we were not included. And in the second list, your Lordship, we were senior to those who have been given appointment, who are the appellants. So, your Lordship, will kindly allow me to come back on the next and I'll satisfy your Lordship that it is not a judgment in persona. Because, your Lordship, what was there before, Lordship knows sometimes when orders are passed. Lordship, because it was an order in concession. That concession cannot take away my vested right.
Yes.
A concession made by the railways cannot take away my right. Had the railways not conceded.
Ms. Mukherjee, Jagdish won't help you. I'll decide right now.
Lordship, I
will consider and pass my order right now. I will consider your point.
Lordship will kindly.
Did not necessarily go against you. I'll go as I proceed.
Lordship.
So whatever my conscience.
But I was only on that ground. Your Lordship will
Jagdish
consider.
cannot help you because that has been settled by Justice Bosak in a particular way.
The only thing is that Jagdish was my list. I was there in Jagdish's list.
You were all along. So you were there in Jagdish?
I was there and I am here. I was
in
there
the second list
in the second list.
Right.
And your Lordship, when Jagdish was set aside, the second list was revived. And when second list was given a right, then some from Jagdish's group came to the court.
No, you have a point there.
That is all.
Obviously, you have a point.
Well, not all of this.
No, I'll come to you. So, Ms. Mukherjee, I'll hear him on the judgments. I'll pass my order. Yes.
Well, not all the petitioners were placed in the second list. Few of them.
All of us.
Second list.
All of us. I can mark it out for your Lordship if my learned friend so wants.
And apart from that, what else? You are Mr.
I'm Mr. Saurabh Mondal, my lord.
Mr. Mondal. Mr. Mondal, yes. What about the rest? What about the judgments?
I would like to
in name and in person.
I would like to take some time to respond to this judgment, my lord, because I am led by Mr. D.N. Roy, who is not present in the court, my lord. I'm junior.
D.N. Roy,
kindly give me.
My question is in person to you.
Kindly give me some time to respond to this judgment, my lord.
I'll respond to this judgment. Probably will lose the case. I mean, right now I'll pass my order. I'll whichever way my conscience guides, I'll pass my order in the passing case. Learned counsel for the petitioner has the petitioners have challenged a decision of the railway authorities in picking and choosing among some of the candidates for an apprenticeship with the railways, although according to the petitioners, they were equally placed with the candidates chosen. Next para. The cardinal dispute in the present case relates to the eligibility of persons holding final National Certificate of Vocational Training within bracket NCVT bracket closed versus those candidates for the apprenticeship who hold provisional NCVTs. Next para. All of the petitioners are provisional NCVT holders. Next para. In the facts of the present case, an initial challenge was preferred in the context of the provisional holders having been debarred from participation in the training for the apprenticeship. in the said challenge, the said challenge was turned down by dismissal of the writ petition filed by some of the provisional holders. First up, the said dismissal found place in a reported judgment of Jagdish Dwivedi and others versus Union of India and others, reported at 2017 SCC Online, Cal 9272. Subsequently, another writ petition was preferred, in connection against a second list which had been published by the railway authorities, this time including provisional holders as well. Next para, the learned single judge taking up the second writ petition, bearing WP 5143 within bracket W of 2018, disposed of the said writ petition, video order dated January 17, 2019, by observing that the authorities proceeded to publish the second list, doing exactly what the High Court said could not be done, and accordingly quashed the second list issued by the authorities. Next para, some of the provisional holders of NCVTs preferred a challenge by way of an appeal against the said order. The said appeal was ultimately disposed of by the concerned division bench, video order dated March 9, 2022. Interestingly, it was recorded in the said order that Learned Counsel for the Railways had considered that after completion of the then ongoing training of private respondents, who were holders of NCVTs, the railway authorities would duly consider the issue of sending the appellants therein on training in accordance with law. The appellants therein, which is to be noted, were all provisional holders and not NCVTs. Next para, it was accordingly observed by the division bench further that the counsel for the appellants agreed to such stand, and in view of such stand being taken by the railway authorities, the appeal was disposed of accordingly, with the expectation being recorded that the railway authorities would consider the case of the appellants therein after completion of the training of the private respondents within a period of 4 weeks to send the apprenticeship training in accordance with law. Next para. It is argued that the present petitioners are provisional certificate holders, who were a part of the. You were also applicants in Jagdish.
Some of them were.
Very well.
I wouldn't know, Your Lordship.
You are not sure. Were a part of the second list, which was quashed by the learned single judge on the second writ petition, and the said order was reversed in appeal. It is argued that, in any event, in view of the concession of the railway authorities before the appellate court, as well as the findings of the appellate bench, a right has accrued in favor of all provisional certificate holders to get a chance to participate in the apprenticeship training program. Since some of the provisional holders were given such opportunity, as per the concession of the railway authorities themselves, there is nothing to distinguish between the other provisional holders of similar certificates, to deprive them from getting a similar opportunity as the appellants on the previous occasion. Next para, in support of our contentions, Learned Counsel cites a judgment of a learned single judge of the Madras High Court in such and such, reported at 2008 SCC Online Mad 1518. The learned single judge expounded the distinctions between the judgments within double inverted in rem, double inverted close, and within double inverted in personam, and observed, comma, inter alia, comma, that a final judgment on the merits of a particular proceeding in rem is an absolute bar to subsequent proceedings founded on the same facts, and such a judgment may be pleaded as a bar to another action of the same subject matter, comma, if its effect is to merge a distinct cause of action but not otherwise. First of next para. Learned Counsel then cites a judgment of the Supreme Court in state of UP and others versus such and such, reported at 2015 1 SCC 347. First up, in the said judgment, comma, the Supreme Court had laid down the ratio that the normal rule is that when a particular set of employees is given relief by the court, comma, all other identically situated persons need not be treated alike by extending that benefit not doing so would amount to discrimination and would be violative of Article 14 of the Constitution. First up, next para. It was observed that this principle needs to be applied in service matters more emphatically as the service jurisprudence evolved by the Supreme Court from time to time postulates that all similarly situated persons should be treated similarly. First up, therefore, comma, it was held, comma, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, comma, they are not to be treated differently. First up, certain exceptions were also considered by the Supreme Court in the said judgment. First up, next para. Learned Counsel, appearing for the respondent authorities, submits that the order of the division bench, comma, whereby an opportunity was given to some of the provisional certificate holders, comma, was restricted only to the appellants in the said case. First up, next para. It is argued that as the last decided proposition stands, comma, the order of the learned single judge on the last occasion was clearly that the second list was also quashed on the ground that the judgment of Jagdish Supra was not followed. First up, the learned single judge specifically held, comma, it is argued, comma, that the provisional certificate holders were not entitled to participate in the training as apprentices. First up, the division bench did not overturn the said judgment, but merely made exceptions on the basis of a limited concession given by the railways regarding only some of the provisional certificate holders. First up, next para. A consideration of the judgment cited by the petitioner makes it abundantly clear that the scopes of operation of a judgment in rem and in personam are different. First up, next para. In ordinary legal parlance, comma, Section 41 of the Evidence Act is taken into consideration, comma, which specifically stipulates 4 categories of judgments, comma, which are considered to be judgments in rem, comma, pertaining to the probate, comma, matrimonial, comma, admiralty and insolvency jurisdiction. First up, however, comma, such proposition has been broadened, comma, contrary to the specific stipulations of Section 9 of the Civil Procedure Code and Section 34 of the Specific Relief Act 1963, comma, which bind only the parties to a suit and persons claiming through them, and in case of trustees, comma, also binding the persons for whose benefit the trustees hold, comma, by way of evolution of the writ jurisdiction. First up, next para. The Madras High Court, comma, in the cited judgment, comma, elaborately and in an erudite manner, comma, discussed the distinctions of a judgment in rem and a judgment in personam, and held that a final judgment on the merits in a particular proceeding in rem is an absolute bar to subsequent proceedings founded on the same facts. First up, next para. The Supreme Court, comma, applying somewhat similar principle, although not exactly the same, comma, applied such jurisprudence to service matters. Full stop. In state of UP Supra, comma, cited by the petitioners, comma, the Supreme Court categorically observed that the normal rule would be that merely because other similarly situated persons did not approach the court earlier, comma, they cannot be deprived of the benefit of a particular order passed in respect of similarly placed persons. Full stop. Next para. It was certain exceptions were carved out by the Supreme Court. Full stop. It was observed that those persons who did not challenge the wrongful action in their cases and acquiesced into the same and woke up after long delay only because of the reason that their counterparts had approached earlier had succeeded, comma, such employees cannot claim the benefit of the judgment, comma, being mere fence-sitters. Full stop. Next para. Yet again, comma, the Supreme Court went on to observe that the exception may not apply in those cases where the judgment pronounced by the court was a judgment in rem with intention to give benefit to all similarly situated persons, comma, whether they approach the court or not. Full stop. Next para. Hence, comma, three categories of persons have been carved out by the judgment of the Supreme Court. Hyphen. The first being persons who approach the court and get the benefit of an order of the court, comma. The second category being persons who are mere fence-sitters and idle watchers, comma, who seek to take advantage of an order obtained by certain persons similarly placed and them as them. And thirdly, comma, similarly situated persons who were not parties to the first judgment, but by virtue of the nature of the judgment being in rem, comma, get the benefit of the initial judgment, comma, not being mere fence-sitters. Full stop. Next para. In the present case, comma, we can easily rule out the third category, comma, since I do not find from the judgment of the division bench that any clear ratio was laid down to hold that all holders of provisional NCVTs are entitled, comma, as a matter of right and in law, comma, to participate as apprentices in the railway authorities concerned program. Full stop. Next para. Rather, comma, the learned division bench clearly proceeded on the premise of the limited concession given by the railway authorities, comma, to the effect that the appellants therein would be accepted for training by the railways. Full stop. In fact, comma, the learned division bench observed that the appellants also agreed, and hence the division bench within double inverted takes the stand of the railway authorities and dispose of the appeal accordingly, double inverted close, comma, thereby vindicating the conclusion that the observations of the division bench were entirely on the concession of the railways. Full stop. It was also observed that the railways were, double inverted, expected to consider the case of the appellants, double inverted close, after completion of the training of the private respondents. Full stop. As such, comma, we do not find any clear observation, comma, to denude the conclusions on law of the learned single judge, which was challenged in the appeal, comma, insofar as the ratio of law was concerned. Full stop. On the other hand, comma, the learned single judge had conclusively observed that the ratio of Jagdish Dwivedi Supra would be applicable with regard to the second list, comma, where provisional certificate holders had been admitted but could not have been so admitted. So on such premise, comma, the learned single judge categorically set aside and quashed the second list, comma, whereby provisional holders were also admitted. Full stop. Next para. At the first blush, comma, accordingly, comma, we do not find that there is any judgment in rem or on merits of the law and facts concerned, comma, by the division bench, comma, which may entitle the present petitioners also to a similar relief as the appellants therein. Full stop. However, comma, the conundrum in the present case is on a more basic level, comma, touching the right to equality guaranteed by the Constitution of India, comma, in particular in Article 14 thereof. Full stop. In the present case, comma, in fact, comma, shades of Article 19 of the Constitution can also be borrowed, comma, since the right of the petitioners to earn a livelihood would be directly dependent on their inclusion or exclusion in the training program for as apprentices for the railway authorities, comma, which would earn them future livelihood. Full stop. Next para. It is seen, comma, although no specific proposition of law was laid down by the division bench, or the decision of the learned single judge was not categorically overruled or set aside, comma, what transpired before the appellate bench was that the railway authorities themselves, comma, for whatever reason, comma, had considered that some of the provisional certificate holders were to be considered eligible for participating in the apprenticeship training. Full stop. The same has been honored subsequently by the railway authorities, and they have chosen the said appellants as participants in the oncoming apprenticeship training program. Full stop. Next para. What is clear is that the railway authorities were the authorities who also had published the second list, comma, where they had included provisional certificate holders as well. Full stop. Up to the stage of the learned single judge's order, comma, the opportunity to participate in the apprenticeship training could not be opened up for provisional certificate holders. Full stop. However, comma, a change, a paradigm shift altered before the division bench, comma, where the railway authorities themselves stood by their quashed second list and reiterated their stand that some of the provisional certificate holders would be included in the apprenticeship training. Full stop. Next para. The moment the railway authorities say so, comma, a right is created implicitly in favor of the other provisional holders, comma, since they stand on an exactly same footing as the appellants before the division bench, comma, being holders of provisional NCVTs. Full stop. There is no reasonable classification or intelligible differential between the present petitioners, comma, that is the other provisional certificate holders, and the similarly placed apprentices, comma, who had made the appeal before the division bench. Full stop. In the absence of such intelligible differentia, comma, there is nothing in law to prevent the present petitioners also from being absorbed or considered for apprenticeship training, comma, being due holders of provisional NCVT certificates. Full stop. Next para. A line has to be added here as regards the role of the present petitioners in their plight. Full stop. The fact that the present petitioners could not obtain provisional NCVTs cannot be attributed to the petitioners, comma, since it was not their fault in any manner at all. Full stop. Next para. Hence, comma, the petitioners, comma, merely because their NCVTs were provisional and not final due to the issuing authorities of the certificates, comma, cannot be deprived of an equal footing as the final certificate holders. Full stop. In view of the above discussions, comma, I do not find any reason which is justifiable in law, comma, to distinguish between the present petitioners and the appellants before the division bench in the appeal as indicated above. Full stop. Hence, comma, all the provisional NCVT holders, comma, similarly placed as the appellants in the in MAT number 722 of 2019 and the present petitioners, are also entitled to be considered for apprenticeship training with the railway authorities, having fulfilled the criteria as set by the railway authorities themselves. First up, accordingly, WPA 6271 of 2023 is allowed, thereby directing the railway authorities to permit the petitioners and others who are equally placed, for participation in the apprenticeship training, for which the petitioners applied for. First up, the selection for such vocational training, which has been done and impugned in the present writ petition, shall accordingly be modified by including the present petitioners as well. Full stop. No rest to cause and service. Thank you, sir.
Grateful, Your Lordship.
Thank you. What did you say? Yes.
Original side matters. Any mentioning? Listed matter item number 1 with 2. Gauri Prasad Goenka versus State Bank of India.
And 2, Mr. Shaha was addressing Your Lordship. He had concluded. Mr. Rai was supposed to, he was continuing.
Yes.
At the request of Mr. Shaha, praying for an accommodation for the day, if it could become next week. We've reached out to Mr. Rai. He's very graciously agreed, I'm told. We will come back next week, my lord.
Well, on the prayer of the petitioners, the matter is urgent till when?
Whenever, Tuesday, Monday, Tuesday.
Urgent till
Tuesday, if it could
be. September 5, 2020, Tuesday.
Thank you.
Great.
Yes. Item number 3 to 6. Bali Fabs International Limited and others.
Bali Fabs. You reply probably.
Mr. Chatterjee wanted to take 5 more minutes.
Oh, Mr. Chatterjee was in. Yes. Yes, Mr. Chatterjee. Conclude.
Just a very little bit below.
Yes.
With the other matters, my lord, there was one in one of those matters, they had, my lord, on their own, after the suits were filed and the PSC's report, my lord, they came and, my lord, gave the money back. That was one of the, kindly have a look at the supplementary affidavit that we gave in one of the matters. Bali Jute. My argument remains the same, Milo. There's nothing different. There's just one fact which is there.
Supplementary.
Recoverage. But the PSC report, Your Lordship will find, is at page 5. And thereafter, my lord, there is a statement made by us. This is
you are referring to which one?
Supplementary, which is WPO number 2252 of 2022.
Yes, supplementary affidavit of that.
Yes, my lord.
Yes.
Then Your Lordship will find, my lord, the suits were being filed at page 3, paragraph 5, and
yes,
adjustment. And after, my lord, this happened, after, my lord, the PSC report came, which is at page 5. And my lord, holding MFL, and then all the companies there at page 6, if Your Lordship sees.
Right. Yes.
12 cases were forwarded, my lord, to the CBI, out of which my lord will find Bali Jute, Ombika, which is also before Your Lordship, and Neelkanto, and all of them, my lord, were forwarded to the CBI. And these are all part of, my lord, the Kankaria group. And thereafter, my lord, the money which was recovered after this, which your lordship will find from our statements, your lordship has already found that, and also from my lord. Lord, there is a chart which your lordship will find at page 7. In terms of the recommendation, the government acted against them. Page 7. This is the Ministry of Textiles' my lord, action, and there's action on my lord, MFL, then Uma, Nilkantho. On my lord, this is, and the money suits being my lord, referred there as well. And after that, Lord, the money which was recovered from Bali jute, my lord would find at page 13. At page 13. This was just
recovered means it was deemed to be given to them under the subsidy and then recovered.
Recovered.
This mode of recovery is peculiar. Otherwise, PSC and all those arguments I can understand. But
mode of recovery, my lord,
either you say they are entitled to it, pay them, and
stage.
recover the money in whatever way, or you say they are not entitled, don't give them.
I am now saying, my lord, they are not entitled at all in terms of the PSC recommendation.
If you say that, then you cannot adjust them with the.
No, this was for the earlier scheme. This is for the MM4 scheme. This is not this scheme. But I am now saying, my lord, with due to their conduct of my lord, taking money, and my lord, there was discrepancies which we found out. But now we say, my lord, they are not entitled to it at all, because the government, my lord, has taken action on the PSC report, and now they've asked us not to, my lord, disperse the money to them. So the stoppage is, my lord, from the government of India, against whom they have no grievance. I cannot disperse till, my lord, government of India, my lord, allows me to disperse. And your lordship also recalls, my lord, my argument on that, my lord, it's the scheme of the government of India, which they acknowledge.
They have acknowledged.
It's not upon their acknowledgement.
Which scheme?
The present scheme.
Yes, they have to acknowledge. They are asking for that. Yes.
On the that it's the government scheme, my lord, that they have not.
Government, that's right.
I am not the government. I'm too small a fry. Now, government of India is not before your lordship to explain, my lord, why they can't get the money. It is for the government of India to come and explain before your lordship, and they have not chosen to, my lord, add them either. Now, this is the one aspect in this matter, my lord. My lord, it's again on the point of recovery. So I did not want to show much, but there is a recoverable amount from Bali jute, which your lordship will find at 17, and my lord, it was recovered from them and adjusted. But this was with respect to, my lord, to the earlier scheme. And this is only to show, my lord, that they've acknowledged that there was a wrongdoing in the earlier schemes. This is basically to show your lordship that. My lord will find it at page 17 at the bottom.
17 of?
17 of that supplementary.
That's right.
It was also decided that Ombika India Mills, Jute Mills, and Usha Corporation are of the same group of Bali Jute, and the dues of Ombika and Usha may be adjusted with the claim of Bali Jute Mills accounts.
What is this? I mean, what is this document? What is this document?
This is a sheet. Note sheet from the, my lord, NGB internal note sheet, which we've, my lord, given it for your lordship to, my lord, see. We don't have to, my lord, we haven't kept anything, my lord, to ourselves. We've given it our internal document for your lordship's kind consideration. Now, what we are saying is, my lord, I really don't want your lordship to even get into this for the moment. This is only to show before your lordship is that there was a problem. There was an acknowledgement of a problem, and the government has acted on the recommendation of the, rather, my lord, yes, the government has acted on the recommendation of the PAC and have decided not to, my lord, give money to them. I have got nothing to do but just to disburse. The government wants me to disburse, I will disburse. If the government finds something wrong, it's for the government to take action against them. I don't have a right under the scheme, my lord, for blacklisting. There is nothing given to me for blacklisting. It's all about, my lord, the government. I am only, my lord, a disbursal agent, nothing more than that. Those are our respectful submissions. Not before your attention.
Yes. Yes.
Not 4 or 5 essential points. Scheme is of Union of India, and I have chosen not to make them a party. And Mr. Chatterjee's voice rings in my ears. I've made a note of that. I don't know what the union has done. I don't know. He's getting sandwiched between me and the Union of India. The scheme is of Union of India. One. Secondly, and because I've not chosen to make them a party, I'm not entitled to the reliefs. Second is that limitation. That scheme has been, application has been made or claim. I don't know. I think he also got confused between the two because the scheme makes a difference. Both are within time. But scheme, he uses this interchangeably. So I also got confused. But the scheme is otherwise. So application or claim barred by limitation. I'll take both his cases. Third is that that was about it before he came to that fear factor of the PSC. Inspection. Inspection, that labeling, pasting, something has been labeled, later it found pasted, riveting, embossing, and this mic was shown, sure. And then the fear factor of the PSC. Because we were discussing this, that before most courts, this would have been a clincher.
So what we discuss, you can't say.
Now I'm arguing this, that before most courts.
Here also, the more pressure of matters, it will become a clincher.
Yes. But this PSC, Public Accounts Committee, this is happening in the parliament. What is going to happen? Most courts, this would have been a clincher. It's our good fortune. Where this court, I don't think just the name of this PSC is going to become a deterrent. That's straight. This is
Totally.
This is getting live.
Utter oil.
No,
utter even. It is utterly oily.
Utterly. This is not even butter. This is oil. It's unhealthy. It is unhealthy.
Duplicate of a different level.
Utterly butterly, but delicious at the end of
Who doesn't like?
Now, my lord, scheme not by Jude Board.
Your Lordship, remember that story of Bidhan Chandra Rai?
No.
This was told to me by my senior, by Ajit Panch.
Right?
What Ajit Panch? Milord, there was one gentleman. Bidhan Chandra Rai was the fairest of all, Milord, chief ministers we've ever seen. So there was one person who went and said that apni ei, apni oi, apni shei, apni hantal, and he wanted something from him. So he reluctantly said, "Acha, thik hai, chada." So somebody, Milord, from his close circle, said, "You never do this. Why do you do it?" Say, "Bhool hole shunte to bhalo lage."
Exactly.
So delicious.
Yes, delicious.
So first point, Milord.
Yes.
Kindly comes to page 22.
Come back, Milord, if you're Lordship.
Yes.
No.
Yes, Mr. Varati completed.
Yes. Page 22.
Page 22
of the application.
Which
of Milord, sorry.
Of
Thank you.
twos.
Sorry. Milord, 2222. This is Bali Fab. Because this is where every page has been shown from.
Yes, right.
Convenient for your Lordship.
Page 73.
Page 22.
22, you said.
Yes.
Bali Fab.
Yes, right.
National Jute Board.
True, yes.
Now kindly turns over, Milord.
Yes.
To two clauses I want to indicate. Lordship will kindly come to page 24 once. 5. This they have only shown.
Right.
The National Jute Board will operate the scheme. Now, Milord, most importantly, kindly comes to page 27. In 5.
Yes.
In case it is found that the incentive has been availed of on the basis of any false information, the company shall be liable to refund to National Jute Board the incentive availed, the rate of interest, prime lending rate of NJB's banker, at the time of invoking this penal clause. So they float the scheme, they operate the scheme, they take steps for recovery. And please make a note, my lord, all these suits, there is no question of a Union of India anywhere. All these suits have been filed by the NJB. They are the plaintiffs in all these suits. Now, one more clause in this aspect I'll show, my lord. And I'll show to your lordship why NJB has filed it.
Yes.
And also why the law gives me the status of being dominus litis. I get to choose because I'm claiming a benefit under this scheme. Now, kindly just once come to page 28.
Yes.
III.
Yes.
Applications complete in all respect and submitted by the units under I and II above. Technical fees per mills, 50,000, so and so. Disregards all that at payable and to be submitted to NJB, which will be examined, processed, and disposed of by maintaining the seniority of the date of receipt of the completed claim applications. So application I make to NJB, it is the duty of the NJB to look at. Now, most important, Lord, 11. A total funding of 19 crores shall be provided by the Ministry of Textile to NJB for 4 years under so and so. The NJB shall disburse funds to the respective eligible applicants against the non-plan grants from the Ministry of Textiles. So everything under the scheme, the person who receives the scheme, who floats the scheme, who examines the scheme, who receives the fund, and whose obligation under the scheme to disburse the money. And whose obligation it is also under the scheme to take the refund if the money has been wrongfully taken by an applicant. It is nobody's case here that NJB is short of funds. That this fund was not given by Ministry of Textile. With regard to PSC, I'll come, and it's the most malafide defense I've seen. And I'll be able to highlight that from their own document, but I'll come to that later. 3 other aspects have been. So this has nothing to, in this entire scheme, your lordship will not find the Union of India playing any role at all, except the funding that comes. And I am saying that the NJB has taken my application. NJB has scrutinized it. NJB has inspected it. NJB has found all these inspections to be in accordance with. NJB shall therefore give it to me because I'm eligible under the scheme. So Union of India has nothing to do with now whether Union of India can impose a condition on a statutory authority which has floated a scheme by which that statutory authority can withhold that benefit under the scheme is for your lordship's consideration. Now, why is this right given to NJB to file all the suits, my lord? Because of this. Kindly have a look at this act. Thank you. NJB is a... Yes. So NJB is a statutory body. It's created by a statute, and most importantly, my lord, kindly have a look at 3 subsection 2. The board shall be a body corporate.
Right.
By the name aforesaid, having perpetual succession and a common seal, with power to acquire, hold, and dispose of property, both movable and immovable, and to contract, and shall be by the said name sue and be sued. So it is a statutory body which has floated a scheme, which has the obligation to pay the money under the scheme. And all these suits, which is their ostensible defense, has also been filed by this statutory body. The Union of India has not come after me. And this thread that they keep dangling, that Union of India has directed, absolutely incorrect. Their own documents will show Union of India has had nothing to do with this. I genuinely doubt why only excerpts of that PAC or whatever they call it. I don't think it's a PAC. I think it's the NJB's own internal meetings and documentation which is on record. It is not a recommendation of the PSC, but I'll still give them the highest credence for that. But I'll come to that later, my lord. So Union of India has played no role here. And if I'm otherwise found to be eligible under the scheme, and if your lordship is otherwise with me, then my lord, I'll take that up in contempt. Let them take that as a defense in Section 8, impossibility of performance. The money is not mine, I'll not be able to pay. But because in law, this is not countenanced. Because the law mandates that you are a statutory body, you have floated a scheme, you are the disbursing authority, you are the receiving authority, you are the scrutinizing authority, you are the authority who is going to seek refund under the scheme. I will not make the Union of India a party. It's not required in law. Because I can't claim a mandamus against the Union of India to give me benefits under a scheme where the Union of India is not floated. If I had made that, the Union of India would have come and said, I'm not a necessary party to the list. That these clauses with regard to, my lord, Union of India. Now, with regard to limitation. If your lordship is at page 28, 28, my lord, your lordship was shown page 23.
Yes.
3. The scheme will come into effect from 1st October 2013 and continue up to the 31st March 2017.
Yes.
And your lordship was shown a date of application saying outside, gone. Limitation hits. Now, because this point was not pleaded, I fell for that excellent drafting because it was just one line beyond the scope of limitation. I did not really look this up because to me it was a non-starter. But now they've argued this, so I'll have to show 2 clauses, my lord, to your lordship. So, my lord, the scheme contemplates 2 things. One is own finance, one is bank finance. Now, in this matter, scheme 1, which expires on 2017, and there was a reason why only this particular scheme and application was shown, because for all the other schemes, the second scheme, and all the other applications in all the matters, it's within this period that's mentioned of the scheme. So my difficulty in limitation that they've argued will apply only for Bali Fab, scheme 1, application 1. Even for scheme 2, application 2, it's within that period, but it doesn't matter. I'll indicate to your lordship why. 2 things Manoj will kindly make a note of. But kindly comes to page 26. Your lordship will read the first 2 lines only.
Yes.
Such acquisition or installation shall be preceded by an intimation to NJB in writing and the intention for such expansion, modernization units along with scheme. NJB will involve so and so, may be considered by technical quantity and notified by NJB, all of this. Then B. The applicant will be required to submit claims. Please mark this word, will not claims. Within 1 year, to be extended to 18 months under special circumstances from the date of issue of the in-principle approval. So either 18 months I don't need. So there's an in-principle approval, which is actually the application that I make, which is my LOI. My claim that I'm making has to be within 1 year from the date of this in-principle issue. But there's also a reason why this authority has gone ahead and inspected and given a report, found certain machines to be in order. This is why there's no question of limitation. For bank finance, kindly comes to the next one. The applicant will be required to submit claims within 1 year, again 18 months, from the date of disbursement of the last installment of loan by the bank or financial institution, or from the date of installation of machinery, whichever is earlier. So this scheme period is irrelevant. Because on the last day also somebody gets an in-principle approval of the scheme. So that is when the scheme is there. The scheme itself, now there is a distinction between this LOI and the claim, the application and the claim. This is where I'm claiming the benefit. The other is the time period within which I have to make the application under scheme. If that application had been after the scheme.
You had made the application within time.
Within.
But the claim was made later on.
In terms of B and E, that I'll show. That also I'll show.
Yes.
My Lord, kindly, Lordship will just have a look at page 30 once now.
Yes.
2. In case of funding of modernization is effected through finance from bank or financial institution.
Yours is own funding.
Mine, she gives me a minute. Konta own funding, konta bank? First is own funding. Only Bali Fab, this writ petitioner, scheme 1, application 1 is own funding. For all other schemes, all other matters, it's bank finance. But in all other matters, limitation is not an issue because the application and the claim is made within that period. So that is not an issue.
So in this case, own funding.
This is own funding.
Yes.
Now, kindly have a look at B.
Right.
So one is own funding, the second one is bank.
Correct.
But this is regarding bank finance.
This is regarding bank finance, but I want to highlight this one aspect.
Yes.
I'll show that.
Yes.
The application for claiming the incentive will have to be made. So the scheme makes a distinction between time period for making an application and time period for making a claim. Please don't rely on anything on what I say. Kindly have a look at B. Such application shall be made within 1 year from the date of disbursement of last installment by bank or finance institution or from the date of installation of machinery, whichever is earlier. Now 3 is in case of upgradation, modernization, own resources. Now your Lordship will turn over to E at page 31. This is own finance.
Yes.
E kindly makes a note of me. The claims can be made only after installation and completion of modernization process. And accordingly, the date of installation shall be cut-off date of the claims provided all other eligibility criteria. So now your Lordship will read E with that clause, which pertains to making the claim. So when I make the claim, the cut-off date is installation. But there is a separate time period for making an application. Am I now 32L? Two wrong clauses were shown and limitation was argued. L. Such application shall be made within 1 year from the date of issue of in-principle approval to the upgradation modernization proposal or during the continuation of the scheme, whichever is earlier. So I make an application. Then that is processed. Everything is found to be an order. Then I make a claim. That claim gets verified by way of an inspection. And I'll show that entire thing is there. While your Lordship is at page 32, my Lord kindly makes a note of that and comes to one document.
No, here, Mr. Banerjee, yes, apparently there's an interchangeability between claim and application. Why? Page 32 says, please take page 26 and 32 together.
Yes, my Lord.
Page 26, the applicant will be required, this is B. The applicant will be required to submit claims within 1 year from the date of issue of the in-principle approval.
Correct, my Lord.
Again, L says at page 32, such application shall be submitted within 1 year from the date of issue of in-principle approval.
My Lord,
so how do you reconcile the two?
This, because this is with regard to submission of claims.
Yes.
26B is time period for making claims. The applicant will be required to submit claims within 1 year from the date of issue.
Again, page 32 is application.
The word claims is not there.
No, such application shall be made.
So application I make.
Yes.
So now your Lordship will turn over, my Lord, to 126. I'll show 110 ones. Here, look.
Are you trying to say that you leave the court? Definitely not. Yes. Yes, Mr. Manish. I thought there is something implicit in 26 and 32, which Mr.
Even I thought that you were Page 110, Milord, makes the entire process very, very clear.
Yes.
Own source.
Right.
Jute mill unit to approach NJB with a letter of EOI for purchase of machinery and complete the same in 9 months from date of EOI. This is the LOI. On completion and purchase and installation, mill to approach IGM in person with the claim application. This is the distinction. So first I make an application where I express my interest to come under the scheme. Yes. Then there is an in-principle approval. Then I purchase the machinery, install all of that. It's in the same within 9 months from the date of the EOI. Then on completion and purchase, I make with the claim application. So distinction that I'm...
Which is the claim and which is the application?
Well, the first one is the application.
The very first clause.
First clause. To approach NJB with a letter of EOI. Then for purchase of machinery and complete the same in 9 months from the date of the EOI.
That is the application.
I make the application. There is the LOI is only the in-principle approval. Then there's an arrow. Now, on completion of purchase and installation, mill to approach IJMA in person with the claim application. So they contemplate two different things. One is I make an application.
Yes.
Saying I'm going to modernize or buy. Then I do that within the time which is at L at 32. Then once that is done, then I go to claim that benefit. That is the period. Then that claim application comes in then. Then with the claim, everything else follows.
Right.
Now, there's a reason why this authority has also gone ahead and done it. And I'll tell you, Lordship, why. Now kindly turns over to 127 once. This is their document, their inspection report. 1, 2, 3.
So after the claim application, they acquiesced to that and they took steps after that.
Look, I'll place my case a little higher here.
All right.
I have not done anything contrary to the scheme for them to forgive and then acquiesce. I have done it exactly in terms of the scheme.
They could not take the point of limitation after having processed their claim.
After my process, the point of limitation is not available because of page 127. I did not annex all this. No, not just because they have done the inspection, because of 3. Kindly have a look at this. 3. Date of application. 1st December 2016. And date of claim. 21st August 2017. I'm not an acquiescence or waiver. Right. There is a reason why in their own document, they have also had the need to identify this separately. Because the scheme contemplates these 2 separate procedures. I apply, your Lordship allows, then I claim. It's like I'm mentioning before the court. Your Lordship allows the mentioning. That's my date of application. I come at 10:30. Lordship allows it. I come and claim for the relief. That's the distinction. That is why date of application is 1st December 2016, right, which is within the period of the scheme, because scheme expired in March 2017. And my date of claim is within 9 months.
So your eligibility is taken care of after the application.
After the application.
It's seen whether you are eligible or not, and
that's right.
Approval is given to you. Then you go ahead and make your claim.
My foot in, I open the door by way of the application.
Yes.
I come in and get examined on the basis of the claim.
Right.
And this, your Lordship, remembers, saw, my Lord, that 9 months in that their own scheme.
Yes.
Your Lordship has seen my date of application is 1st December 2016.
In that, yes.
And this is within 9 months. Which is why they did not say you're out of the scheme, I will not inspect. They've come out and inspected because this is in terms of their own scheme. So limitation point should not have been urged. It's contrary to their own records here. This distinction possibly skipped Mr. Chatterjee's attention between an application and a claim application. One thing is to come into the door saying, may I come in? That's within the scheme. And please examine what I have done is within 9 months from my entry into the room. Now, Milord, this is with regard to limitation.
Yes.
Third point was with regard to inspection. Because it was said that this Mr. Chatterjee had argued, Milord, that there are a lot of issues. Some issues have not been resolved.
Chatterjee also insinuated that, your previous conduct and all, and the scheme is not an absolute right sort of thing. Yes.
I'll come. The cornerstone is PSC. His cornerstone is PSC, and I'll place that PSC thing because I will require Lordship's finding on that because because I read this yesterday, and I think there was slight malafide here. Possible, it's possible. But with regard to his argument regarding inspection, he had said that embossing this,
yes,
and he had highlighted certain comments,
yes,
that some machineries were not found in order, and he had said that how do I know? Today you're asking me to disburse funds. How will I know? This is his technical committee who has gone. And one thing that again possibly skipped his attention is the claim that I have made here is in respect of all machines which were found to be in conformity with the scheme.
In your case, there was no specific refusal by them.
Nothing.
Great.
But even then, in this page 127, I'll just highlight, forgets all of the first clauses from right of the table. If your Lordship will find, last column, remarks. At page 127, last column has remarks.
Yes.
Some have remarks, some don't have remarks.
Yes.
So the ones that don't have remarks have no remarks to be commented upon. Those have been certified at page 129, clause 4. Inspection team observed that the above imported machines are procured new and in operation. The date of installation and technical specification of the machine are found to comply with the claim application of the unit submitted to NJB under ISAPM. My claim before your Lordship is restricted to only those machines in respect of which there is no comment, which have been found to be in order. And most importantly, my Lord, this is scheme 1, application 1. Scheme 2, application 2, inspection report, not one comment. Everything was found to be in order. So one thing is to argue on the point of prejudice, embossing, affixing, attestation. I have not claimed those benefits here. I have restricted my claim, which your Lordship will find it is by way of a chart that I have made and had indicated when I had argued, my Lord, at page 139. All these machines,
yes,
all these machines are only those machines against which there are no remarks. This in respect of scheme 1, application 1.
Right.
Trust my memory, I won't forget. So there's no point highlighting these to the court. IJRA report, TAR not found, technical appraisal report. I'm not claiming in respect of those. But for the other ones, which are bank finance, all inspections have been returned in respect of this. I'll be able to show to your Lordship, not one comment. And there it was within, your Lordship will not rely on me, I'll just exemplify this from the document. I wanted to save the trouble of taking your Lordship through all the page numbers once, but just for my satisfaction, kindly have a look at page 186 of the second volume. This is scheme 2, application 2, bank finance. My Lord has made a note that the second scheme was valid from 1st April 2017 till 31st March 2020. Date of application, date of claim. And just while your Lordship is still on that, once just gives it a cursory glance on the remarks. Nothing. All of them were found to be in order. There are no remarks. And they've certified that at page 187.
This is regarding the second scheme.
Second scheme.
Yes.
Second schemes kept second application.
Polyfabs have applied for both these schemes.
Polyfabs applied on both the schemes, but the facts are identical in respect of that. That we'll highlight, not in a very short note for your lordship's convenience.
Right, right.
Now, my lord, the next most important point of PSC. Your lordship has been shown an act. Your lordship has been shown the rules. Please come to the supplementary affidavit that is filed with regard to the PSC. And examines with me once, my lord. And I again can hear Mr. Chatterjee say that I don't know what the Union of India has done, because the lordship put a query to him.
Yes.
That have you blacklisted him? He said, I don't know.
Okay. Yes, this PSC sort of thing.
Page 4.
Yes.
The date will be of some relevance, my lord. 2nd May 2022. This is being written by the Undersecretary to the Government of India to, I'll disregard the name, NJB. In continuation of this ministry's email on the above mentioned subject matter, and to say, your lordship will find that all this is post the 4 or the 3 writ petitions. On the above matter, no, that could be an incorrect submission. I am withdrawing it because these are all 2022. This 29th April.
Yes.
This 29th April might be before.
Yes.
On the above mentioned subject, and to say that these observations made by the Honorable Chairman PSC on 28th August 2022, the input, comments, reply on these observations, please mark the next 4 words, is still pending from NJB. It does not lie in their mouth to come and tell the court that I don't know what we have done. So this thread that is dangled, that Union of India, this report is being sought from NJB as to their action taken report. NJB has sat on it. Accordingly, keeping in view. Now, my lord, next page. And I doubt the next pages. My lord, I doubt the fact whether this is a recommendation by the PSC or this is a part of a document by which NJB is replying to the ministry. Lord, initially, status of cases lying with CBI. Initially, 3 cases as indicated below have been taken up suo motu by CBI. Argument was advanced that the Union of India complained or we complained. This was suo motu by the CBI. The progress in the cases as reported by CBI by their letter dated so-and-so, 24th August 2020 is as hereunder. Again, MFL, your lordship will find a suit has been filed, amount has been recovered. Now next, my lord, CBI ACB under that table. CBI ACB has disposed of the case against Ganges Manufacturing, unconnected, stating that the case is disposed of as FRT as sufficient evidence was not found against the accused person. However, CBI ACB has recommended, so PSC, CBI ACB has recommended blacklisting the company from availing benefit under NJB scheme.
What is SCB? I don't know. Something of the CBI.
Some bureau, some corruption bureau would be.
Yes.
And anti-corruption bureau, correct.
Right.
Anti-corruption bureau. So there is no recommendation by PSC here. CBI has recommended blacklisting the company from availing the benefit under the NJB scheme. As per direction of NJB, an internal note, your lordship will kindly mark this, the internal note is NJB/PSC dated 20th October has been issued to strictly ensure compliance with direction for blacklisting Ganges from getting any subsidy in NJB future, nothing with regard to me. Letters have also been sent to the Office of Jute Commissioner and Jute Corporation of India by office communication again, NJB, dated 13th October 2020, with a request for implementing the directives of CBI. Your Lordship can demand an apology for wasting the court's time on PSC rules, PSC Act, and unnecessarily threatening the court with PSC. NJB, by its letter dated 25th August, have forwarded the balance 12 cases for taking up for investigation by CBI. Your Lordship will find 1 and 8, this I had pointed on the last occasion, Ambika and Bali Jute. No steps have been taken. So in respect of Bali, Fab and Kelvin, no CBI cases, no recommendation. In case of Ambika and Bali Jute, recommendation by NJB to CBI, no steps taken. 1 CBI case instituted against one Kakrania. This Honorable Court has stayed that investigation. Because in one they filed FRT, this one they wanted to unnecessarily gun after this particular person. This is the order of stay, Milord. So the only investigation against one promoter, it is Ashokidina, please. Thank you. This is 22nd. This is the order of stay. 22nd September 2022. Your Lordship will find the name Avanti Kumar Kankaria. He was a promoter of these 4 companies. No recommendation for CBI case by NJB. So, Malad, this is an incorrect submission that I don't know. Union of India, what is there? Make them a party. This is your letter. You are recommending to the CBI, please start cases. For your Lordship today. Now, next, Milord, again, please, page 5 at the bottom, because I don't think this is a PSC recommendation. Again, at the bottom, NJB has been, CBO NJB has been interacting regularly with the concerned CBI officials, DIG, and who is in heading the organization in Kolkata. Regular follow-up meetings are being done to garner progress in these cases. It appears to me that this is, they got stoked by the ministry saying, what have you done, give? This is their reply. Now, again, there is an observation recommendation. This is going to be important. The committee note. Now, this I don't know if it is a PSC or not. It could be. This again could be the PSC. The committee note that the following audit observations, NJB Ministry of Textile has taken legal action against jute mills for recovering the subsidy amount wrongfully drawn under acquisition plant MM4 scheme. Some of the jute mills have refunded the amount, not me. The National Jute Board has also filed 18 money suits against the other mills as per the directive of the Public Accounts Committee. Regarding the time frame for recovery of so-and-so involved, the committee has been informed that the court proceedings have been delayed due to pandemic and these would be taken up after normalcy returns. The committee would like to be apprised of the outcome of the money suits filed. The committee has also been informed by the Joint Inspection Team have been constituted for undertaking physical verification and inspection of all 124 jute mills which have received subsidy. The committee would also like to know the details of the final report. The committee recommends that all the involved in the irregularities related to capital subsidy be blacklisted from availing any benefit under any scheme of the government in future. This is of 2022. I claim a benefit in respect of a scheme which is expired in 2020. Apart from the fact that there is no blacklisting, and your Lordship repeatedly questioned the respondent here that how can you do this? So he says, I don't know. So this direction was on the NJB to show what have you done. There is no blacklisting. And the direction was also from availing under any scheme of the government in future. Because blacklisting, the PSC at least, because it's a constitutional body, understand that it's prospective. I am claiming benefits under a scheme which had been passed and floated and approved prior to this recommendation came even. And also, nobody has acted on the basis of this recommendation. There is no blacklisting. On the contrary, Your Lordship would have found that the PSC wants to know what they have done with regard to the suit. What they do is this illegal adjustment. They understand, they signed a report to the PSC for all the might that the PSC has, that this is the only legal way that one can withdraw money or take back the money. They file the suit, recover it against this, and now they've gone and withdrawn the suits. Because they claim not just principal, interest. Your Lordship recalls that last thing that had shown in Bali Jute. Principal, interest, everything refunded, suits withdrawn. 4 lakhs is to be disbursed. Now 4 lakhs take and go. And where is the this actually fails me. So what appears to be the first 2 pages, page 1, page 5, is really like an action taken report where NJB is recommending. Then there is a PSC recommendation on which this is August 2023, no steps have been taken. But it can't be heard. The NJB can't be heard to say that we don't know what has happened from the same place where they got these documents. Because this comes by way of a supplementary. So they got these documents later. Therefore, Your Lordships allowed it. They could not have taken out if there was a blacklisting. Union of India would not have forwarded them, assuming that they got this from the Union. If there was a blacklisting, Union of India would not have given.
The ministry also reminds again, next page, page 8, asking for reply.
Sorry, Milan.
Next page, page 8.
Yes, again.
Again, the PSC asks for a reply.
Reply from NJB.
Yes.
Milan, 8 actually precedes 4. Right. This is March 24, 2022. 4 is 2nd May 2022.
Yes. Page 9 starts abruptly, apparently.
Well, that's what I'm saying.
Yes. No, what is it? I mean,
this they say, I don't know. This appears to me to be again.
Yes. From the middle of nowhere, actually.
From the middle of nowhere, it starts. They can say that, they wanted to save a lot of time of going through irrelevant documents, only relevant extracts were taken out. But what is this document? Nobody knows. Whether this is a recommendation of a PSC.
The last page is also
not there.
From the middle of
which is why I'm saying, there could be a, had Mr. Chatterjee not been there, I would have used stronger words. But it doesn't appear to me to be anything that requires so much sanctity of law. And what this also Your Lordship will find. Recommendation and jute mills who have been found to be involved in the irregularities, they be blacklisted. There is no finding of irregularity against me. So everything I understand is in a homogeneous unit. There's CBI progressing. CBI is conducting an inquiry. If I'm found to have, in the suit, they could have found me that they've withdrawn. So where is the finding that I have done this fraudulently or there is an irregularity in how I've gotten it, which translates into an order of blacklisting, which blacklists me from taking benefits for all future government schemes. This is dated, and I'm very grateful, Manoj. This is dated, Your Lordship has seen, at page 7. At page 7, last line, I had marked it, I had missed it.
Yes.
Ministry of Textiles, so-and-so, Fiber 3, dated 21/4/2022. So this recommendation for blacklisting in the future, if there is a blacklisting, only after I'm found in an irregularity, will be for future government schemes. But that's really a side argument, not because there is no blacklisting. On an anticipation, your lordship is expected to return a finding that because PS is involved, I'm expecting that there's an order of blacklisting, which is not born from anywhere. And your lordship will record this undertaking that if there is a blacklisting and they show it, your lordship will send us to prison from here. If there's an order of blacklisting that's been served, now I don't know what they'll come up with. So I come back to these 2 points, and I don't think your lordship needs to be troubled with the act, the guide, the rules for implementation. Rules are there for implementation. Implement it. Do it in accordance with law. I am before a court of law. It has to be justiciable in law. And in that NJB scheme, if your lordship finds Union of India has any role, dismisses my application with 1 lakh cost.
Only.
Sorry.
Please.
That's the highest I could have really braved enough to say.
After so much argument, 1 lakh.
So I come back to those 2 points, the extraneous,
yes.
And these are really recommendations which have not been given. These are respectful submissions. Lordship will allow us to give us notes only to assist your lordship on the factual aspect.
No, please do that, because just refer to the page numbers.
Page numbers,
that will help me, yes.
And I'll give notes for 4 different matters.
That will also, yes.
Otherwise, it will be confusing.
Give copies to them also, so
yes,
that
yes,
you can also.
I'll do that.
So, when should I keep it for filing?
It gives me a week or two.
Good. Arguments are oral arguments are substantially concluded. Full stop. Learned counsel for the parties are requested to file the written notes of arguments. Full stop. For such purpose, comma, let the matters be listed at the top of the list on 8th September. On September 8, 2023.
Very grateful.
Thank you. 8th September. Top.